আমার বড় কাকা করে চিৎকার করে যখন চিৎকার করে না চিৎকার হয় না যখন দেখি চিৎকারের ইস্যু তখন চলে যায় এনার্জি আর চুপচাপ হয়ে যায় ও চুপচাপ
Yes. Give it.
And we permitted to make an item number 30 of today's list notice. Taken up, your notice are directed to taken up
Very well, it will be taken up.
So may we be permitted to mention one bail in connection with appeal.
For inclusion.
My lord, formal matter for the
Yes, call the list.
Item number 1.
Your Lordship,
Mentioning.
Yes.
Your Lordship, e-mentioning,
E-mentioning.
item number 1, Your Lordship.
E-mentioning could have been. Yes. Yes, what do you want?
Your Lordship is aware that yesterday there was a hearing and I appeared in item number 116. And Your Lordship observed that I was not allowed to be participated in as a respondent of that matter. My name is not appearing in the order sheet, Your Lordship. So for correction and inclusion of my name in order sheet, I am moving this e-mentioning, Your Lordship.
But I was for the appellant. I was for the appellant.
They to be included, otherwise.
But I felt, Milord, since section 5 was taken up, Milord, probably his appearance subject to Milord's
It will
consideration.
be Monday to be mentioned. Monday to be
Milord,
mentioned.
since your Lordship is not sitting singly, Milord, I just wanted to mention one writ petition to be taken in Milord's single list. If Milord intends to sit singly next week anytime.
I am sitting singly next week, 12 at 1 o'clock.
So, Milord, can I hand up the Milord writ
Give
petition
it,
number?
give it, give it.
Yes, Milord, grateful.
Your
Continuation,
Lordship,
that's why otherwise I would not have troubled your Lordship.
Yes, who is for the petition?
One 374 of Indian Penal Code and Title Section 6 of the Protection of Children from Sexual Offense Act after framing of the charge. The allegation is murder on the faithful date, murder the abduction was made. Who is a 14-year old and the commitment of rape was offered. Well, this is the allegation. However, the petitioner who said on the very next day, that is 29th of May 2025, which means he is in custody for more than 2 years. That means most specifically 770 days as on date. Now, my lord, 164 statement of the girl. That is obviously against me because it is tutor. But the actual fact is the boy is of 19 years old, the girl is of 14 years old. There was a love affair. The parents that was not accepted by the parents. Parents tried to shift the girl to
Medical,
my lord.
usual story, madam.
There is other things, lordship. My lord, there are lordship. My lord, therefore, my lord, they prepared for to clear away. My lord, all documents, my lord, WhatsApp chats are there. Those were placed before the trial as for identification. My lord, lordship, kindly see the medical report.
On the next page, on the reverse. Hymen is rupture. Hymen is rupture.
Page 15
Fourth.
and 16. Lordship,
No, hymen rupture.
my lord. My lord, there is the allegation.
The girl was made to consume some intoxicating articles also.
My lord, there was an allegation of the forceful abduction, forceful commitment of rape. Lordship, kindly see paragraph to page 16 of my petition. I don't know what the page number of the CD. Page 16 of my petition. Physical examination, lordship will get the paragraph number 2, general appearance and emotional status, normal. My lord, thereafter, my lord, C, A, B, C, D, these are not present. 4, my lord, scratches, bites, bruises, lacerations, etc. not present. So my submission, my lord, if my lord the car was taken forcefully kidnapped and my lord the forceful commitment of rape was done, my lord, on the very next day, my lord, the medical was done. My lord, no, my lord, sign of forceful anything which is forceful. No bodily hurt, bodily injury. Now, my lord, the boy is of 19 years old, lordship. My lord, the trial has been started.
Just a minute, ma'am, just a minute.
Yes.
Why the medical as available in the CD
and the medical report as has been annexed at page number 15 differ.
My lord, I'll just check this.
It's number 16.
Dated, my lord, dated medical.
Date of medical is 26/6/2023. Just a minute, please, will you please check once?
My lord.
ওখানে তো দেখুন মেডিকেলটার সঙ্গে তো পেপার করে যাবে চেক whether correct CD has been given or not.
As soon as when the alleged abduction was done, the disaster coordinate was informed, Lordship, and petitioner, without insulting the petitioner, without including the police, which is very low. There was something happened between the petitioner and the daughter of the disaster coordinate. However, and when the trial started from August 2020. And
August?
But, and today the date, July, here,
Victim has been examined. Victim has been examined.
Examined. Father of the victim has been partly examined. My lord, I would like to invite your lordship's attention to the deposition of the victim.
Just.
Surprising, my lord, there are good.
Lordship,
At the time of commission of the offence, what was the age of the,
40 years.
no, what is the age of the petitioner?
19 years.
Lordship, may I have-
Just a minute.
My lord, there are two medical.
Okay.
I fail to understand, my lord. This is the same person, same victim name in that.
Your client's name is Dibyendu Dotto. Dibyendu Dev.
Mr. Vishesh, hymen rupture is nothing conclusive. It may happen for various reasons.
My lord, this is not a case of a single boy took care of a girl. She loved with a single girl, a single boy, no. If there was a group, three were involved, the ambulance was used, she was abducted with the help of an ambulance. During her evening walk. A very serious allegation, thereafter she was raped. And in the cross-examination, they have admitted the abduction in the cross-examination. In the cross, they have admitted.
So us.
Yes, lordship. Here is
Whose cross is this?
Dibyendu, on behalf of Dibyendu, my lord, trying to see, while trying to shake the witness, the admission has been done in the cross. When shaking the witness, admission has been done. The allegation is that they were planning to sell the girl. It is in the FIR in the 154 lot, in the evidence also. The very serious allegation, a girl of 14 years age, she was kidnapped and they were planning to sell her against 60 lakhs, 70 lakhs rupees.
Yes. Yes. No, sufficient.
Lordship, kindly see that WhatsApp messages which have been placed for identification at the time of.
It has practically lost the significance because of the examination and cross-examination of the victim. Take down. Her learned advocate for the petitioner, learned advocate for the state and learned advocate for the de facto complainant who appeared today by filing Vokalatnama.
Lordship, I undertake to file it. Thank you.
Who undertake to file Vokalatnama in course of this day. Stop that. In course of her submission, learned advocate for the accused petitioner submit before this court that considering the false implication of the present accused petitioner and also considering the long detention of the present accused petitioner, the instant application for bail may be considered favorably. Stop. Therefore, bail is opposed not only by the not only on behalf of the state, but also on behalf of the de facto complainant. Stop. Now, the advocate for the de facto complainant in courts of his submission draw the attention of this court to the examination of the deposition of the PW1, that is the victim girl, wherefrom we find sufficient incriminating materials as against the present accused petitioner, which are really grave and serious in nature. Stop. Considering the grievousness of the offense, we are not inclined to exercise our discretion in favor of the present petitioner, and accordingly, prayer for bail is refused. Considering the long pendency of the trial, learned trial court is hereby requested to expedite the trial and to conclude the same, preferably within a year from the date of communication of this order.
Item number 2.
It is anticipatory bail. Yes. What is the offense?
2 and 6, same case diary.
2 and 6.
Same case diary.
Who is for the 6?
High Court.
Okay.
But 2 is anticipated.
Okay. So which one will take first? Bail or anticipatory? Bail. Item number 6 then. Item 6. What is the nature of offense, sir?
For a 302, for a charge sheet submitted against 5, for a out of 5 person arrested, custody alert, I mean, those they are custody more than 220 days. For a case is a place of circumstantial evidence. An allegation is for there is a previous enmity between the party and subsequently of the fateful day. For the dead body was lying beside the house of the that is the allegation.
How we have been implicated? Last thing together.
But there is previous enmity as per the FIR and previous enmity.
What is the, have you annexed the written complaint?
Yes, sir.
I
Where?
have
It
it.
is fact copy I read. I see the last page.
No, that is charge sheet is there.
Lordship, I am handing.
See, please see it.
Here it is. Lordship says written complaint lodged on 1st December 2022 by the complainant Nirod Burman, that is brother of the deceased.
Sorry.
The brother of the deceased, Nirod Burman, lodged the written complaint on 1st December 2022.
Yes.
The fact is that the petitioner of this petitioner, that is Nokul, which one? 6th. The Bipul and Bamun and Nokul, that is 2 and item number 2 and item number 6, all are full-blooded brothers. They had this previous enmity with the deceased and his wife. Now, Lordship, on Lordship, kindly see page 28. It will be
It is a double murder.
double murder. Page 28 of my case diary, Lordship.
Where both the spouses have been killed.
Spouse has been killed. Lordship,
Page number 28.
28. I have marked the portion.
My involvement.
Yes. I have marked the portion with the pencil. Prior to death, when they attacked the couple called one person over telephone that I have been attacked by these person, the Bipul and his brothers. Please call the police. That person also informed the police and various person also. When they reached, the body was recovered. The PM says Chandana Burman, that is the wife, antemortem injuries, homicidal nature. And the Babu Chandra Sarkar, that is the husband, asphyxia due to strangulation. So it was both homicidal murder. Now, prior to that death, at the time attack, this Babu who died called a person that I have been attacked by this person, please inform the police. And that person informed the police as well as some other person also. They are giving this statement that Babu called me. And all these person, item number 2 and 6, they are brothers and all they attacked together. Due to some family dispute, that was it.
There is only one witness who stated that.
No, there are other witnesses also.
The recovery of the offending weapon, page 30 and 31, under the section statement of 27, from Kartik and Bamun,
30 and 31.
page 30 and 31.
Just a minute.
That is another brother. So the brothers is the Kauravas.
The offending weapon has been sent to the FSL for ascertain the offending weapon or not.
Page 30 and 31, that
That is the recovery statement prior to the.
when our post is 37 of another brother Kartik. Post recovery statement. All the brothers attacked victim. 32 and 34 witnesses of Caesar.
Take down.
And page
Hard learned
135
advocate for the
judicial
petitioner.
foundation.
A learned advocate for the state at length. It is contended on behalf of the petitioner that considering the false implication of the present two accused petitioners and considering the fact that investigation has already been completed, the present accused petitioners may be enlarged on bail on any condition whatsoever. Stop there. While opposing the prayer for bail, learned advocate for the state took us to the different portions of the case journey. It has been shown that prior to the alleged incident of double murder, a serious quarrel took place between the deceased persons and the charge-sheeted accused persons. It has also been shown to us that as per statements of one of the accused persons, the weapon of offense was recovered. Stop. Such being the position, and considering the grievousness of the crime, we are not inclined to exercise our discretion in favor of the present accused petitioners. Accordingly, prayer for bail is refused.
Lordship, another is the anticipatory bail, same. So
Same the letter to
2 and 6.
6 এটা 6 আইটেম নাম্বার 2 টা অলমোস্ট সেম হবে তো এটা ভালো এটা বলে দেবো আমি বলে দিচ্ছি it is contended on behalf of the accused petitioner that considering the fact that the investigation has already been completed and therefore custodial interrogation of the present accused petitioner is no more necessary. The present application for anticipated bail may be considered favorably. এবারে উনার স্টেটমেন্টটা একই হবে in view of such তারপরে যেটা হচ্ছে we are not entitled to exercise our discretion under section 438 এটা
Grateful, Lordship.
Item number 3.
not today.
Item number 4.
No, my lord, I am appearing for the state.
What is the nature of offense?
This is POCSO.
6 or 4.
6 of October.
Lordship, I am renewing my bail application. It was rejected on February, 3 months ago. And still now the evidence is not started. Lordship, the reason for I am making this application is that when the brief came to me, Lordship, after going through the case report, a serious doubt occurred whether this person is the accused who has committed the offense or not. Lordship, I take your Lordship to the FIR first. FIR lodged by the complainant.
FIR, it has been mentioned that I, that is the petitioner, Molay Burman, is a plumber working in the street, that PG plumbing of the fuel. I was working there, and
Mamuni Adhikari is the mother, Mamuni.
Mamuni Adhikari was the complainant.
What is the stage of the trial?
Charge sheet filed on,
One second.
charge sheet filed on,
All right,
seven-
all right.
Now she kindly says that I am the plumber, I am no one related to the house, or they don't know me prior to this incident. I am a plumber who was working in the street, fixing the fuel. It is the in the FIR. Now kindly see the 164 of the VG, victim girl, the kid. He says, Molay Bakun, it is. So I am Molay Bakun, I may be Molay Bakun. But Lordship, the doubt is that the 164 of the complainant, 164 of the complainant, that she said that the person who has committed Molay Bakun, you know the Molay Bakun, namesake, simple minor namesake, is the friend of the son of his brother-in-law. And that Molay Bakun had acquaintance, prior acquaintance with them. He used to come to their house. All that is mentioned in the 164. But if FIR, I'm Molay Bakun, who is the plumber working for fixing the pipe at the beach.
Your client's name is Molay Rai,
Molay Rai.
but you have written is Molay Burman.
As because the police has arrested me as Molay Burman. Now, second point is, Lordship, he's a 4-year-old.
No, his name is appearing in the 164 statement.
Yes, Lordship. The name
Why
is
is the
there.
discrepancy?
The name is there, but as in the FIR, the Molay Burman, the accused is the plumber working in the street fixing the fuel. But in 164, that Molay Burman or Molay Rai is the friend of one of their relatives and used to come to their house and were previously known to them. These facts have not been mentioned in the FIR that he used to come and we know them previously. Nothing. I was an unknown person in the FIR, but in the 164, that person who committed.
Your actual name is Molay Rai.
রায় বর্মন লিখে তো
আমি বলেছি টাইম কল ঠিক করছিল, আমাদের বাড়ি থেকে টাইম কল ঠিক করছিল, তার নাম মলয় বর্মন, চকলেট দেওয়ার নাম করে এটসেট্রা এটসেট্রা বলি। So where is the discrepancy? I cannot find.
my lord, maybe my lord, that Molay Burman, Molay Rai is same person, my lord. Maybe.
So
Matter of trial, my lord.
Is as per the FIR, the accused who has committed the offence is a person unknown to them, is a plumber working in the street fixing the fuel. As per the FIR. But as per the 164 statement, you see, Lordship says, I am Molay Burman, I am not Molay Rai. But it says the name of that person is Molay Rai, who is the friend of the son of his brother-in-law. Brother-in-law, and is to come to their house and no, his name is Molay Rai. I am Molay Burman. Now, it is saying maybe
বড়মা দিদির ছেলের বনু এসেছিল।
like
বন্ধু
but as per the FIR, the person Molay Burman who has been arrested is an unknown person plumber working in the street. Currently, this is the FIR Lordship pending.
Cannot be a major discrepancy.
Six popular. Six popular. Lordship, I am Molay Rai. The FIR is Molay Burman. Lordship.
May I, my lord?
Lordship, one second. One second. Just 1 second. I am Molay Burman. The 164 says Molay Rai. Now one question is a 6 popular. Aggravated penetration of a child, because paralysis the medical. Paralysis the medical.
21.
Very good. It can be considered by the learned trial court at the time of framing of charge.
Now, Lordship, there are two things. I am Molay Burman. The 164 says Molay Rai. Molay Rai is the friend of their relative. I am a plumber, Hon'ble. Medical says no, nothing.
May I, my lord?
So 6 POXO cannot be attracted, Lordship. Aggravated penetration. 6 POXO cannot be attracted.
How long you are in custody?
I mean, custody, Lordship, since
9/9/2022. 9/9/2022.
about 1 year.
Yes. Her learned advocate for the petitioner, learned advocate for the state at length. At the very outset, learned advocate for the petitioner submitting for this court that investigation has already been completed.
Charge has already been made.
Stop. And charge has already been
Fixed
framed
for-
as
fixed
against the
for trial.
present accused petitioner. Stop. It is further argued that considering the discrepancy, of the allegation in the written complaint, comma, the version of the victim in a statement under section 164 CRPC, and the version of the mother of the victim, it can be easily presumed that the present case is absolutely false one, wherein the present accused petitioner has been unnecessarily implicated. Learned advocate for the state, however, opposes such contention. It is contended that before the learned trial court, the case here has been matured for trial.
Yes.
Stop that. We have minutely perused the entire materials of the case there. We have also considered the rival submissions as made at the bar. Stop. Investigation is stated to have been completed in the meantime, and charge is also stated to have been framed as against the present accused petitioner. On conjoint perusal of the written complaint, comma, the statements as recorded under section 164 as referred to above, as well as the medical examination report of the victim, we admittedly find some contradiction which appears to be prima facie very prominent. Such being the position, we are thus inclined to allow the plea with some stringent conditions. It is as ordered that the present accused petitioner may find bail of rupees 10,000 with 2 days of a like amount. Satisfaction, learned judge, comma, special court, within bracket POXO Act, Jalpaiguri. Stop. It is further ordered that the present accused petitioner shall appear before the learned trial court on each date of substantive hearing, subject to the provision of section 370 CRPC, with a further condition that the present accused petitioner shall meet the investigating officer of this case once in a week till conclusion of the trial, unless such condition has been relaxed by the learned trial.
Grateful.
Item number 5.
We have said next circuit.
Next circuit.
I'm for the state to go.
Item number 7.
I'm for the state.
I for this.
The column 17 of the chart sheet. I am taking the chart sheet. You will find it from the back side. Column 17.
So the allegation is that the father killed the husband,
Father killed the son.
father killed the son,
Yes.
youngest son.
Can you keep the evidence?
Affidavit of
Evidence. Before this court. From the
yes.
de facto accountability.
What is your submission?
Mercy pitch. I'm 64-year-old. The lordship has seen the fact of the case which has been transpired from after completion of the investigation. And it was there is a provocation on the part of the they feel I could not predict it. The FIR maker is my elder son. He resides beside me, not in my name. He got separate.
Yes.
164 statements are there. Postmortem report are also there. Wasn't premeditated at all.
At the very outset, learned advocate, hard learned at the very outset, learned advocate for the petitioner subject before this court that considering the fact that the present accused petitioner is languishing in JC for a considerable length of time and there is no chance of his absconding, the instant application for bail may be considered favorably. Learned advocate for the state, however, opposes such prayer. On perusal of the entire materials of the case diary, it reveals that admittedly the allegation as made out in the FIR gives due support in course of investigation. Stop. Investigation is stated to have been completed. Stop. In our considered view, this is not a fit case for custodial trial, especially when no case has been made out on behalf of the state that in the event the present accused petitioner is enlarged on bail, he may abscond and or he may tamper with the evidence and or he may cause threat or inducement to the witnesses. Stop. Considering the entire factors as discussed above, we are inclined to allow the instant application for bail. It is an order that the present accused petitioner may find bail out of rupees 5,000 with 2 days, 2,500, 2 days suitable like amount. Satisfaction, CJM Alipurduar. It is further directed that the present accused petitioner shall appear. CJM Alipurduar, very good. It is further that the present accused petitioner shall appear before the learned trial court on each date of substantive hearing, subject to the provision of section 317 CRPC. আমি যে কন্ডিশন গুলো বললাম ওই কন্ডিশন গুলোই রাখবেন, অন্য কোর্টে অ্যাড করে দেবেন না। না না আগে ঠিক আছে।
Item number 8.
Not today.
Item number 9.
My lord, 9 and 10, the same case diary. It is
9 and 10 will be taken up conjointly.
Yes, my lord.
Yes.
Kindly fix it, my lord. Where is that? Kindly fix it on Tuesday. I don't have the CD, my lord.
You are appearing on behalf of the 9 and 10 also, yeah?
Item number 11.
For the state lordship.
Just run the candidate tomorrow.
Candidate.
The 439 or 438? What is the allegation against you? 307 is there. Political rivalry.
Lordship,
What is the nature of injury?
Nishit Pramanik, our Central Union Minister, while his convoy was proceeding, some miscreants, they heard bomb fired, allegation, pelted stone. So this case started. Lordship kindly says no injury to any person.
Specifically named by anybody?
There are on the page 264, 265, 266, 161 eyewitnesses. They names various, but not this person. Lordship, I may fairly say. But he is named accused number 2 in both the FIRs. One lodged by the CISF, and another lodged by the Mondal Shahapati of a political
Recent
party.
incident.
Recent incident. Incident is still proceeding.
Separate. Tomorrow I am the candidate. I have.
What is your name?
Lordship, his name is Taposh Dash. Kindly see page 264, 265, 266. Another is page 10 to 12. 161 of eyewitnesses.
You are named in the FIR.
Yes, accused number 2 in both the FIRs.
How many are named?
Many. More than that.
Yes,
More than 30.
413, hard learned
More than
advocate for the
30.
petitioner, learned advocate for the state at length. Para- On behalf of the present accused petitioner, is contended that the present case is the outcome of a political rivalry wherein the present accused petitioner has been falsely implicated. Stop there. Learned advocate for the state, however, opposes such claim. Stop. On perusal of the entire materials of the CD, it appears to us that the present accused petitioner is very much named in the FIR. Stop. It further appears to us that there are some intimating materials as against the present accused petitioner. However, however, in our consideration, those materials are not sufficient to reject the prayer for bail. Keeping in mind that in the CD, as on this day we have found, no injury on any person. Stop. Such being the position, we are inclined to exercise our discretion in favor of the present accused petitioner. It is an order that present accused petitioner may find bail of rupees 5,000 with 2 registered CO2 like amount. Satisfaction, ACGM Dinata. It is further ordered that the present accused petitioner shall meet the investigating officer of this case once in a week till submission in final form.
Item number 12. Thirteen. Item 14. Item 15.
CD is not available. CD is not available.
CD not received.
15, 16 and 18.
Not today.
Not today. 16 and 18 is same matter, same case study.
16 not today.
CD
CD
not-
not received.
Item 17.
Not today. Tuesday, Tuesday.
Item 17,
Lordship, CD is required, Lordship.
Not there,
Wait for
Tuesday then.
Tuesday.
19,
Passover.
20,
20 Passover.
21,
Who's for the state, sir?
And for the state.
What is the nature of offense?
304. Actually, we are preparing this application for the second time. Our application had been dismissed on 29th of November 2022 last year. On the ground, that was before the trial had begun. The charge was not. Now today, the scenario is that the charge is done. The trial is already almost completed now. It is 11 out of the prosecution. Out of 30 prosecution witnesses, 11 has already been implied. Lordship, previously, if I take to your lordship, 11 of my petition. The reason why the honorable court has dismissed my application was because the offending vehicle was covered as an intent of the petitioner on the basis of the leading statement made by the accused person. Now, this was what the prosecution has submitted before the trial had come. Now, Lordship, I would like to put attention to page number 20.
20? Yes.
So this is the Caesar witness. This is the prosecution witness number 6, and she is one of the Caesar witnesses. Now, what she has said is subsequently the IO of the case recovered and seized the weapon of offense. That is one iron chain in my presence and obtained my signature on the Caesar. Now the signature was obtained on the.
You are reading page number 23.
23.
Which portion?
That is just below cross-examination by defense, 2 lines about that.
Huh.
Subsequently,
Okay.
the IO of the case recovered and seized the weapon of offense, that is one iron chain in my presence and obtained the signature on the Caesar. Now, during cross-examination, what is there is towards the end of the cross-examination about it, voluntarily, I put my signature on the state Caesar list at our home. Now, she has mentioned at our home during inquiry by the police with one other ranked police. No, there is no whisper of the presence of the accused person when the Caesar was signed.
But see, see, 1, 2, 3, 4, 5, 6, 7, 8, 9 line from the top of the examination in chief. Read out. Money Bomjan died.
Money Bomjan died due to the bleeding from mouth arising as a result of assault by an iron chain by the accused Hon'ble on 6 years 2020.
So,
No, Lordship,
in cross-examination, is there any contradiction?
she was not an eyewitness. She was never an eyewitness. Lordship would be perplexed to see what has happened is all the statements made by the prosecution witness are similar in it. Similar. Even the complainant was, if your lordship would peruse, even the complainant was not present in the place of occurrence, and he is stated as if that he was present there. Now the incident had occurred on 5th of August.
Come to page 18 also. Come to page 18. On the date of incident in the evening at about 7 p.m. when my son such and such came back home, all of a sudden the accused Wangdi Sherpa came in house with a cow, with a dog tying into such and such and started to assault my son in back. So this is an eyewitness of our son.
But no, this is an eyewitness.
Wait, but as a result of this assault, my son received several marks of injuries on his person, and he asked me to take photograph with his mobile phone, but I do not know the use of mobile phone. The accused also assaulted my another son, Somam Burgan, for which he also sustained injury on his person. So eyewitness accounts are there. Let the trial be completed. We are directing the learned trial court to conclude the trial within 3 months.
The trial has already been begun. Only 2 of the witnesses is remaining for the prosecution. What is the word of my publisher?
No.
Lordship, please, may
There are eyewitness accounts there.
That is true, but there is a contradiction in the.
No contradiction.
No contradiction.
Lordship, there were 2 eyewitnesses. She is saying one. Now.
If there be any contradiction, raise that before the trial court.
That is great, Lordship, Frank. Lordship.
Sorry.
Lordship,
Come.
I would only draw
You
your.
are not
attention
in
to one important, Lordship, just what has happened was, this has not come out in the record. What has happened is that the incident had taken place on 5th. Now, the deceased. person
That kindly visualize our predicament. We cannot do anything which is outside the record.
Lordship, that is what I am saying. I have the record, it is there in the record, Your Lordship. On the 9th, I have gone to the hospital.
Eyewitness accounts are there.
Lordship,
That
please
your
don't-
client's involvement is privacy prominent.
We are expediting, we are
We
expediting.
experience. Please come.
Lordship, please, Lordship,
This
please,
is
please,
the
already custody
petitioner
for 320
Renews his prayer for bail, which was rejected earlier by a coordinate bench by an order dated November 29, 2022, passed in CRM bracket DB bracket 404 of 2022. Paragraph. The petitioner says that he has been in custody for a long time, stop. He has been framed in this case, stop. He has no role to play in the alleged incident, stop. The learned counsel for the petitioner tries to point out inconsistencies in the depositions of the prosecution witnesses, stop. Sir, when a judge dictates order, the minimum courtesy is not to interrupt. You will know. Certain inconsistencies in the depositions of prosecution witnesses, stop. Paragraph. The prayer for bail is opposed strongly, not only on behalf of the state, but also on behalf of the de facto complainant. Stop. We are told that 11 out of 13 prosecution witnesses have already been examined. Stop. Paragraph. We have seen the depositions. Stop. There appears to be eyewitnesses to the, at least one eyewitness to the alleged incident. Stop. Paragraph. In view of the aforesaid, we are not inclined to exercise our discretion in favor of the petitioner. Stop. Paragraph. However, considering the lengthy detention of the petitioner, we direct the learned trial court to conclude the trial at the earliest and preferably within a period of 4 months. 3 months.
One eyewitness. Actually, there were 2 eyewitnesses.
At least one, we said.
There are 2 eyewitnesses.
At least one would include 2.
Great.
Within 3 months of communication of this order.
Learned trial court is directed to act on the saga copy of this. It will be easier for you.
Item number 22. 23.
23, I am appearing for the state, your lordship.
24.
24, my lord, I am for the state.
24 pass over.
25.
Tuesday.
26.
Not today.
I am for the state, lordship.
For that matter. Column 10. Column 10.
May I lordship?
You are rude.
I am for the state.
Yes.
Lordship,
Have you considered the judgment?
Just wait, please renew your submission once again.
We have seen the facts, the facts.
It says that the coordinate bench of our High Court says that if there be any gap in the memo or itself,
Or any of the family members, then coordinate it and also the honorable Supreme Court has that not paid.
what is your case here?
lordship, on the last occasion, lordship wanted to see a judgment where Supreme Court has been reached to hold that in technical issues cannot be judged in the time of constituting whether making a judgment. Reported in 2020, volume 9 STP 549 lordship. Technical issue গুলো এখন দেখা যাবে। Now these officials,
This is not with respect to arrest memo.
no, I'm coming to another thing. Now, lordship, this judgment, the Supreme Court was pleased to hold that the official acts, unless the trial commences, these are all the seizures and all these are official acts. These are to be presumed to have been done properly, and a presumption under there is a presumption under section 114 of the Evidence Act. Lordship.
Which portion? Which paragraph?
Lordship. দুটোর সময় করবে?
2 PM.
2 PM. Lordship.
Why?
Actually, I got this copy just now. I just
So we are keeping it passover.
lordship.
Passover. In the second call, it will be taken up. And are you in possession of those judgments
Lordship,
which you have given?
it is 10 point. Similar matters are fixed at all.
But in 2020 also in this same ground, what the honorable coordination has done that
Let us see what he wants to place before us, because this is NDPS,
It is a 4 PM matter.
this is section 52 compliance, NDPS.
Yes, lordship.
There,
No, that day, what happened, lordship wanted to see a judgment where technically it has been ignored by this.
no, you can't generalize, Mr. Vishwash. Section 52 is one kind of technicality, maybe the signature on arrest memo.
Independent witness. I will come to that
Yes.
point also. I have a.
Come to that straight on that
Oh,
point. Yes.
And I am aware of the coordinate bench judgment. Judgment.
No, not only coordinate bench, Supreme Court also. Have you given him copies of those?
No, I
judgments?
don't have the copy of the Supreme Court judgment.
You don't.
I am aware of the coordinate bench
He has
judgment.
to consider, tell him the citation. They can
No,
consider.
in the judgments of the coordinate bench, the Supreme Court judgments have been relied upon.
Lodge.
As your sister had handed over to us, we have gone to.
Don't have to.
Mr. Ganguly is sitting there.
4 o'clock.
Lordship and one of the Mr. Ganguly was reading me that also, I have got.
On this ground, he obtained bail.
I opposing that also I have. That
You should not mention that. My late father used to say, practitioners are like hired gundas. Whoever.
Item 27.
I am for the state, Madam.
in this case, I filed a supplementary affidavit that where I have annexed the medical documents of the petitioner for which he is suffering from cancer. And your lordship has directed me to submit judgment with regard where bail has been granted and the petitioner is suffering from cancer.
Critical illness need not be any, whatever it is.
Sufficient materials are there, my lord. But it's unfortunate, 20-year-old lady and suffering from cancer. They filed a affidavit.
How long have you been in custody?
In your petition, you have taken that down, your illness?
Yes.
In which paragraph? Yes, paragraph number 3. Regarding the cancer of my wife. Just a minute. Who is suffering from cancer?
Shaina Begum. There is 2 accused persons.
Ma'am, kindly read the paragraph number 3 of your application. What do you want to say?
That's a prosecution.
Oh, this is supplementary.
Supplementary
I see,
affidavit,
I
my lord.
see. Oh, application. In your application, you have stated
Which paragraph?
which paragraph? Kindly say, tell us.
Four, paragraph.
Four, paragraph 4.
Stomach cancer.
Charge sheet submitted. Trial has commenced. Trial
There
has
is no reflection.
not commenced. The petitioner is charged with offences punishable under the NDPS Act. Purota debe, huh? Stop. Charge sheet has been submitted. Stop. The petitioner says that he has been in custody for 9 months. Stop. He prays for bail.
He organized,
She, Sonam, lady, she, paragraph. Learned advocate for the state opposes the prayer. Now, he says that there is sufficient incriminating material against the petitioner. Stop, paragraph. We have considered the material on record. Stop. Investigation is complete. Stop. Trial is yet to commence. Stop. The petitioner is a cancer patient, which is not disputed. Stop. Paragraph. In view of the above, we are inclined to exercise our discretion in favor of the petitioner. Paragraph accordingly, condition gulo
439. Satisfaction, NDPS court. Learned additional session judge, second court, within bracket লিখে রাখুন special court, NDPS Act at Siliguri. Condition দিলে আবার treatment problem.
Number 28.
Hmm?
29.
Tuesday then.
Item number 30.
Four PM.
31.
I'm for the state.
Thursday.
32.
Item number 32.
With the federal court of constitution, it has been stated the petition was found with contravent in Hon'ble. The Hon'ble is listed from from charge sheet, from FIR, no but in Hon'ble.
Rejected or last circuit. Last coordinate was rejected on
Only paying to.
5th June.
This are not taken up. Only paying to. The entirely possible. There are many aspects. Two gunny bags that is NDPS case, this is the most important thing. These two gunny bags is missing. I say why I mean, then one of two gunny bags is 50 kg. 50, that man was not holding that gunny bag. He was only found standing near that gunny bag. And it is absurd that a man will carry gunny bag weighing 50 kg. And no other man was found near him. It's very absurd.
Who are the scissor witnesses?
These are witnesses are
Who are the scissor witnesses?
No, should discuss the later.
one more thing.
Just a minute.
When he found standing near anything, he cannot be told to be positive. Another thing, this performed as the gazetted officer in the police officer, it has been clearly stated that third and figure has been done under his supervision. This directly contrary to the spirit of the NPS Act. The officer who is acting as a gazetted officer, he can never supervise that. Such officer position. But it has been clearly stated that he was supervising. This is custody for 280 days, madam.
That is like. Yes, what is your submission with regard to his submission? Please confine to that.
Yes, Rashid.
Yes, Mr. State Advocate. What do you say? Where are the gunny bags?
Yes. Her learned advocate for the petitioner and learned advocate for the state at length. At the very outset, learned advocate for the petitioner submits before this court that this is his client's prayer for renewal of bail, basically on the ground that a serious doubt occurred.
Lordship, there is plastic bag, Lordship, it is plastic gunny bag, Lordship.
Where it has been removed.
Lordship, 52 kg, Lordship, commercial
Just-
quantity.
A serious doubt occurred with regard to the seizure of the alleged contraband articles. Drawing attention to the written complaint, it is submitted on behalf of the accused petitioner that it is the case of the prosecution that on the fateful day and hour, the present accused petitioner was found in possession of a gunny bag, wherefrom allegedly commercial quantity of contraband articles were seized. Stop. Drawing attention to the seizure list, it is contended that drawing attention to the seizure list as well as to the charge sheet, it is contended that surprisingly, such gunny bag was not seized, which raises a serious doubt with regard to the authenticity of the seizure and complicity of the present accused in the alleged crime. Stop that. Learned advocate for the state though opposes such prayer, but in course of his submission, he could not explain the discrepancy as pointed out by the learned advocate for the petition. Stop. We have meticulously perused the entire materials of the series, including the written complaint as well as including the written complaint, the seizure list and the charge sheet. Admittedly, though in the written complaint, it has been alleged that on the fateful day and hour, the present accused petitioner was found to be in possession of contraband articles in 2 gunny bags. But for some unexplained reason, those gunny bags were not seized, which reveals prima facie from the seizure list. Stop. This discrepancy, in our considered view, gives a reasonable presumption with regard to the innocence of the present accused, though in this regard our view is tentative one, and which shall not affect the trial. Stop. Considering the entire materials and basically keeping in mind the aforementioned discrepancy as discussed here above, or aforementioned discrepancy, we are inclined to exercise our discretion in favor of the present accused petitioner. It is ordered that the present accused petitioner may fine bail rupees 10,000 with 2 registered like amount, satisfaction learned special court within bracket NDPS at Siliguri, with the further condition that the present accused petitioner shall appear before the learned trial court on each date of substantive hearing, subject to the provision of section 370 CRPC, with the further condition that the present accused petitioner shall not leave the territorial jurisdiction of the trial court till conclusion of the trial, unless permitted by the learned trial court, and he shall appear before the investigating officer once in a week unless the aforesaid two conditions have been relaxed by the learned trial court. Once in a week till conclusion of the trial court is to meet the IO once in a week. আর উপরে ওই যে unless permitted ওটা দুবার হয়ে গেছে তাহলে ওটা কেটে দাও। Unless permitted by the learned.
Great lordship.
Item number 33.
Three.
On the prayer, on the prayer.
As per request of the learned advocate for the petition, huh? Next, 34.
I have for the state, my lord. I have for the state.
$34.
What is the nature of offense, ma'am?
Nothing was recovered from my possession and my neighbor's transfer from the court statement. It does not have an evidential value.
Is it correct?
Yes, my lord, page 90, 91, 92. 161 statements, no recovery, my lord. Page, Caesar list, page
Page
8, my lord. Page 8.
The petitioner says that he has been falsely implicated. Stop.
He is the
There was no recovery.
member of the record.
Contraband items from him. Stop. His name has transpired from statements made by co-accused persons. Paragraph. Learned advocate for the state admits that there was no recovery from the petitioner
Is the relevant page?
and that his name
Page 90, 91, 92.
come to light from statements of co-accused persons. Paragraph in that view of the matter, from other restrictions in section 37 of the NDPS Act would not apply. Stop. Considering the facts and circumstances of the case and the material on record, we are inclined to allow this application.
No, actually, one thing. Allow the mark को safe ने चाहे ठीक है हाँ ठीक absolutely
My lord, my lord, one in the, this petitioner belongs to Malda, Malda district. So
हाँ
not to leave the district.
वो जो जहाँ अपन आगे बोला
Jalpaiguri.
is further order that the present accused petitioner 10,000 টাকা দুটো ছিল ঠিক আছে that the present accused petitioner shall appear before the learned trial court ওই যেটা পড়েছি যেমন 317 তিনশো থাকবে আর হ্যাঁ আর একটা হচ্ছে shall meet the investigating officer of this case once in a week unless the aforementioned two conditions have been relaxed by the learned trial এই কন্ডিশন গুলো পরবর্তী থাকবে হচ্ছে till conclusion of the trial.
Charge sheet not yet filed.
Charge sheet not filed.
এই চার্জ শিট নট ইয়েট সাবমিটেড টু till conclusion of the trial লেখা দরকার নেই হ্যাঁ না আর কিছু না ওই জন্যই থাকবে সিম্পল ছেড়ে till conclusionটা লিখবেন
35.
My lord,
Tuesday, 35, 35 and 38. State,
my lord, our record reveals not none has been endorsed, not 1 day accommodation.
May we make it Tuesday? Tuesday.
37.
I'm for the state, my lord.
Item number 40.
39, somebody said took accommodation.
Item number 40.
Me, 40?
Amit.
40. Are we little bit fast? Are we little bit fast? But the lawyers have been delayed.
No, man, I was. 325, 307, 506, 34 IPC notice, proof of lordship, contractor and subcontractor regarding their site lordship, there is useful lordship, no injury lordship, then to the false clear lordship.
Yes, Siri, please.
How is your father?
My lord is good.
Where does he stay these days?
My lord being Calcutta Biala.
In Calcutta?
Yes, my lord, Biala on these days.
Does he practice?
Yes, my lord is practicing.
Some monetary transaction took place on account of business.
Yes, both the parties are contractor and subcontractor.
Is there any injury?
No, my lord.
Yes. Heard learned advocate for the petitioner and learned advocate for the state at length. On perusal of the entire materials of the case diary, it appears to us that the present case is the outcome of a business dispute, wherein from the statements of the witnesses, admittedly, the names of the present accused petitioners are transparent. However, considering the fact that as on this day, there are no injury reports in the case diary. No injury reports, no?
No, my lord. No injury reports, sir.
And also keeping in mind that the present case might have arisen, right, out of business transaction, we are inclined to allow the pair. In the event of their arrest, the present two accused petitioners may find bail of rupees 5,000 each in two races like amount. Arresting officer 430 to comply.
Investigation is going on.
Yes, my lord.
It is further ordered that the present accused petitioner shall meet the investigating officer as and when called for, till submission in final form.
Grateful, my lord.
All are in law. What is the stage of investigation?
Charge sheet filed on 30th of April 2023. Their in-laws, principal accused Pratap Burman, he is in custody.
Husband.
Already that.
Well granted.
Yes, Siri, please.
Postmortem is 86, hanging, antemortem in nature.
Postmortem is 86.
Page number 86.
Is there any role or the allegations are only?
161, my lord, I've gone through the 161, page 11, 12, 13 and 14. In the first, no, my lord, they say the husband used to reside with the wife. There was a quarrel before the suicide, but the in-laws were absent from the house. That is in page number 11, 161, my lord. The last question.
Charge sheet,
Fine.
right,
Page 11, 161.
Heard learned advocate for the petitioner and advocate for the state at length. It is contended that the present accused petitioners have been implicated unnecessarily. Learned advocate for the state, however, opposes the prayer. Stop. On perusal of the entire materials of the case diary, we do not find any such incriminating material as against the present accused petitioner to refuse their prayer, especially when investigation is stated to have been completed. Accordingly, prayer for anticipated bail is allowed. In the event of their arrest, the present 5 accused petitioners may find bail out with 10,000 each, with 2 registers like a note each. Satisfaction, learned CJM Jalpaiguri, 432 comply. It is further ordered that the present 5 accused petitioners shall appear before the learned CJM Jalpaiguri within 21 days from the date of obtaining certified copy or server copy as uploading of server copy.
Item number 42.
There's more other matters which would do the advocate on record. The pressure of them come be.
All right. Wednesday.
Monday.
Monday.
not one.
No. Wednesday.
There are.
Under the case counter case, their allegations we attack them, our allegations they attack because my lord, we have found my lord one of the person of the de facto complainant family was found in a compromised position of one of the lady of our family. So we attack them.
Any serious injury?
Lordship,
My lord, our
cut injury.
Our FIR is the first one that is in page 15 of my case. Thereafter their FIR.
Charge
Maybe
sheet,
Lordship, that doesn't give any right to assault the other
sheet,
accused
charge
persons. Lordship, charge sheet has been submitted, Lordship. Stitch over scalp, cut injury, and the accused person, they tried to strangulate the victim, Lordship. That has been stated in the injury report. And Lordship, there are 3 eyewitnesses to the incident, Lordship, where statements have been recorded.
My FIR noted, there are also my lord the senior.
Come.
Injury my
Heard
lord.
learned advocate for the petitioner, learned advocate for the state at length. On perusal of the entire materials of the case there, it reveals to us that the present case is the outcome of a village dispute. Stop. It further reveals to us that the injuries of the victim are not so much serious as stated in the written complaint. Stop. Charge sheet is stated to have been submitted in the meantime. Considering the entire scenario, as discussed here now, we are inclined to allow the trial. In the event of their arrest, the present accused petitioners may find bail out 5,000. Each with 2 registered like amount, satisfaction arresting officer, 432 compliance, surrender before the learned court within 21 days.
Grateful, Lordship.
Item 45.
45, my lord, I am appearing for the state.
এটা কি সারেন্ডার বলছে ন্যাপিয়ার হ্যাঁ না ন্যাপিয়ার ওটা ন্যাপিয়ার বেরিয়ে গেছে থ্যাংক ইউ Yes, 376.
376, your lordship.
Yes.
Rather than the present effect of complaint, lost the complaint on 2nd of May, that on 13th of April at night, the present defect of complaint and present petitioner found the compromising. Thereafter, elder brother of the house gave the story of assault was water, and father-in-law admitted, and thereafter brother-in-law of the defect of complaint lost the complaint. Them was registered as anybody case number 297, 2023. 341, 325, 326, 300, 500, 34 being given. I annex. P2.
Annexure
P2. Page 13.
is 13.
Yes.
That is the previous one.
First complaint by the brother-in-law of the de facto complaint. Present de facto.
Just a minute.
Yes, ma'am.
Accused number 2 is the sister-in-law.
Yes, sister-in-law.
In your written complaint, in the previous written complaint.
Yes.
Amina
Present de facto complaint. Yes, present-
আমার ছোট ভাইয়ের স্ত্রী বটে।
Yes, sir.
That is item is the at that time.
Amina Khatun to?
আমার ছোট ভাই নজরুল বিভিন্ন সময় বাইরে কর্মস্থলে লাগে। So brother-in-law of the accused of that case,
No, sir. Brother-in-law of the present de facto complaint.
or
I
brother,
also in that case accused. First complaint I also accused. Present de facto complainant brother-in-law lost this complaint. Admitted that there is a present de facto complainant having relationship with the present petitioner.
no, who is the de facto complaint in the first case?
First case his brother-in-law.
What is his name?
Next, my-
Nawab Ali.
Nawab Ali made the written complaint
Yes.
against his youngest brother's wife and another accused person.
Also present petitioner.
Present petitioner is
Present petitioner having relationship, Lalit.
Laji Hossain was also accused.
Yes, madam, in that.
All right.
Yes, madam.
And Amina Khatun is his sister-in-law.
Yes, madam. And there is accused number 1 and 2 having relationship admitted in the petition. Madam, in the detailed complaint, there is a case was registered.
Hmm.
Hereafter, on 17th of May, Amina Khatun lodged a complaint that on 13, on the same day, she outside from the room, the present petitioner committed rape upon her.
Present petitioner.
Present Lalit, present petitioner. This is the second case.
So is it your case that on account of family pressure it has been done?
Yes.
On account of family pressure it has been done.
Family present, she lost this first complaint. As complaint admitted that there is a having relationship with Amina Khatun with Lalit Hossain, and thereafter on 17th May, Amina Khatun lost the on 13, on that day, on the same time, she was raped by him.
My lord, may I, my lord?
রাজিক হোসেন দুটো মাস আসামি আছে আমিনা খাতুন এখানে কম্প্রোমাইজিং করে পাওয়া যাচ্ছে ব্রাদার ইন ল অফ দি ডিফেক্ট কমপ্লেন আমার ছোট ভাইয়ের থেকে ওর সঙ্গে রেপে যায় এখন এই ডিফেক্ট কমপ্লেন মানে পেয়েছে এখানে যে আসামি সে এখন বলছে রাজিক হোসেন আমাকে
May I, my lord?
according to it is a consensual relationship was there.
My lord, as per my brother colleague's version, my lord, contradict with the 161 statement of the victim, my lord. Contradict with the 161 statement of the victim, my lord, page 5. The statement of my brother colleague, which he has stated, my lord, fully contradict with the statement of the victim. my
Is
lord.
any medical?
Medical is there, my lord, page 16. Married woman, my lord. Aged about 23 years.
Any external injury or anything?
Not at all. Fairly submitting before your lordship, there is no such medical injuries there, my lord. Investigation is still going on, your lordship. Investigation is going on.
Heard learned advocate for the petitioner, learned advocate for the state at length. At the very outset, learned advocate for the petitioner draws attention of this court to the annexure. What is the annexure?
Written complaint.
Annexure P2. Annexure P2. More specifically, page 14 of the instant application, page 14 and 15 of the instant application for anticipatory bail, wherein one Nawab Ali lodged a written complaint against the present accused petitioner and the present de facto complainant, alleging that the present accused petitioner and the present de facto complainant were found to be in compromising position in their room, taking advantage of the absence of the husband of the present de facto complainant. Stop. Drawing attention to the written complaint as lodged in this case, it is contended that thereafter as per the pressure of the family members of the present de facto complainant, she has lodged a false complaint against the present accused, alleging that she has been raped by the present accused petitioner. Learned advocate for the state opposes such prayer for anticipatory bail. It is contended that the version of the present accused petitioner is otherwise.
Yes.
We have meticulously gone through the entire materials as clear before us, including the case diary. Admittedly, from the written complaint as lodged on 2/5/2023, it appears to us that one Nawab Ali lodged a written complaint against the present accused petitioner and the de facto complainant, since he found them in compromising position. It appears to us that 15 days thereafter, the instant written complaint has been filed. Stop. Such being the position, we cannot overlook that there is chance of false implication, especially when some prima facie material was placed that there was a consensual relationship between the present accused petitioner and the de facto complainant. Accordingly, prayer for anticipated bail is allowed. In the event of his arrest, present accused petitioner may find bail out rupees 10,000 with 2 days to see like among arresting officer for that to comply. Charge sheet not submitted.
Charge sheet not submitted yet.
It is further ordered that the present accused petitioner shall meet the investigating officer once in a week till submission in final.
Grateful, your lordship.
এটা হলো 40 কত হলো?
We'll come back.
We'll come back. আরে বললাম তো কি বুঝলো যাই না। ভুলে গেছে আবার ভারতের কিছু।
He's right. Final.
Grateful, your lordship.
Four 98 at 307. You are the husband.
Husband, my lord.
Is there any injury?
I think, my lord, on the 17th of May, he married and she left on the 1st of May. Matrimonial house and he has done that after day of disaster for your wedding.
গলায় গামছা পেঁচিয়ে প্রাণে মারার চেষ্টা করে। Is there any injury?
Our injury is there, but it's page number 36.
What are the nature of injury?
Simple.
আসুন। Hard করে দেবেন যেমন দেখি। It is contended. The allegation is made out in the FIR. Is the outcome of a matrimonial dispute. And the same is too much exaggerated. An advocate for the state in course of his submission to opposes the prayer. But he submits that the injuries of the victim are simple injuries. Stop considering the fact that the present case is the outcome of a matrimonial dispute where chance of reconciliation is expected to be very high. We are inclined to take a lenient approach in favor of the present accused petitioner. Satisfy 5,000, 2,000 with 1 ratio like amount. Satisfaction ACGM Matavanga 430 to comply to meet the investigating officer of this case.
Investigation going on?
My lord,
Investigation going on?
investigation going on.
To meet the investigating officer of this case
Charge sheet not
as
filed.
and when called for
My lord.
till submission in final.
Item 48.
Well,
Also, CD not available also.
Tuesday.
Tuesday.
49.
And for the state, your lordship. Yes. He is the principal accused. One accused.
Sorry, in that I thought you would have had, but my other submission that allegation on the section 8 is not fine. That is the statement also, and section 7 says the definition of the act, and this is political rivalry. My uncle submitted nomination paper consisting from
What is the allegation?
Lordship, my objection, all cases, your lordship, they are taking only one plea, BJP and Trinamool party, but this is not the case. Case is, your lordships, that the victim lady had been to the tuition. At that time, she followed.
Age 16, age?
Age of victim, 16. Follow up and thereafter tried to and run and but your lordships, one thing to ensure not to disturb the victim.
Yes.
And she is student of class 11. So at the time of going tuition, again, he may be disturbed. So
No, your
worships. Ensure not to disturb in near future.
Submitted on behalf of the petitioner. That the allegation as made out in the FIR is out and out false. And the present accused petitioner has been falsely implicated in this law. An advocate for the state, however, opposes such claim. Is we have produced the entire materials of the case diary, including the statement of the victim as recorded under section 164 CRPC. They are resident of the same area. Boro, no, same area. Ashrampara, same. So, it reveals from such statement that the present accused petitioner is in the habit of ifteasing, habit of ifteasing the present ifteasing the minor daughter of the de facto complainant. Stop. Considering the entire materials of the CD, we do not find there is a fit case for custodial interrogation. And accordingly, we are inclined to allow the prayer with some stringent condition. In the event of his arrest, the present accused petitioner may find bail out of his 10,000 with 2 shares of registered shares of like amount, satisfaction with SEM. No, learned session, learned special judge within brackets special court under POXO Act at Matavana. The catch call. Take it the satisfaction arresting officer code. With the further condition that the present accused petitioner shall meet the investigating officer of this case twice daily for the next 1 month, and thereafter once in a week till submission in final form, unless such condition has been relaxed by the learned POXO judge, learned special judge, POXO court, Matavana.
Worship only one, not to disturb at the time of going
In
tuition.
further order,
That is.
even the present accused petitioner disturbs the victim girl and oblique her family members in any way.
Okay.
Learned trial court is at liberty to cancel his anticipatory bail as granted by us.
Obliged.
Item number 50. Four for state, 379, 524 of the effect of complaint was out of
440, which one is the non-bailable? 379.
was out of hope. 78% were out and then that the allegation. She was not present that time. She did not see after 4 days, the paper was lost on hearing of the from the main doctor. There will be enmity for the student I implicated in this.
Is an unknown affair. পরবর্তী সময় আমার বাস গিয়ে প্রতিবেশী আমার কাছে জানতে পারি তারিখে 1 নম্বর আসনে নেতৃত্বে অজ্ঞাত করে 7-8 জন দুষ্কৃতী মারধর করে তখন If it be an unknown person enter into an uncommitted theft, then why he will come, he will threaten him? Is there any justification?
My lord, 161 of neighbors
Huh?
is there, my lord, and his name is reflected from the statement of the neighbors. CAC spending, my lord.
Oh. জিনিসপত্র কয়েকজন এসে ওই এলাকার দোকান খোঁজ লোকে নিয়েছে। No, the name of the present accused petitioner transfers in the written complaint.
Yes.
That he committed theft.
Yes. After returning home,
Read the page number 10 once. Last portion. Last 3 or 4 lines. পরবর্তী সময়।
yes.
Oh, at the leadership of the accused number 1. Yes, that is there.
And in this regard, 161 statement is specific, my lord.
Is there any FIR by the FIR? Is there any FIR or GD on by the neighbors?
No.
So they have to.
When she returned back, their house was ransacked by this petitioner and the neighbors.
GD করবে এই লোকটা করেছে। আসুন। 438 এ বলো hard. It is contended that out of local dispute, now out of dispute between the neighbors, the present accused petitioner has been formally implicated in this case.
Not kindly see the finally consider page 10, 161.
Yeah, it is here. I have seen.
I mean,
Learned advocate for the state, our opposes such content, opposes such prayer for anticipated gain. We have perused the entire materials of the city. Admittedly, in the statements of the witnesses, the name of the present accused petitioner is very much transparent. However, considering the fact that it is not a fit case for custodial interrogation, we are inclined to allow the prayer. It is order. In the event of his arrest, the present accused petitioner may find the of 10,000 with 2 registers your like amount, satisfaction arresting officer, 432 to compliance, to meet the investigating officer of this case, as and when called for, till submission in final form.
Item number 51.
I am for the state, your lordship.
Ask matter, I move. Ask complaint. Ask complaint, matter. This case, matter, I am the family member implicated in this case.
But in this case, 3 victims are there. In 3 injury reports are there, 17, 18 and 19. 3 injury reports are there, my lord. All are maybe simple or grievous. Investigation complete.
All are simple.
All are simple, maybe grievous, like as that. 17, 18 and 19. 3 injury reports are there.
Oh, you could have moved there at that time, Lajik Hossain.
And the family member.
You are the family member of Lajik Hossain. Is there any injury?
My lord, page 17, 18 and 19. 3 victims are there, 3 injury reports are there, man. Total FIR named accused, my lord, 4 and charge sheeted also against 4 accused persons.
Charge sheet submitted.
Yes, your lordship. 31st of May 2023.
Heard. It is submitted on behalf of the petitioner. That considering the fact that the allegation is without in the FIR is the outcome of a village dispute. And also considering the fact that the investigation has already been completed. Therefore, anticipated bail may be considered favorable. Lord advocate for the state opposes the prayer for anticipated bail. We have perused the entire materials of the city. Charge sheet is stated to have been submitted. The injury reports of the victim shows that the injuries of the victim are basically simple in nature. Considering the entire circumstances, we are inclined to allow our discretion under section 430 CRPC in favor of the present accused petitioner. In the event of their arrest, the present to accused petitioner may find bail is 5,000. 2 days at 2,000 like amount. Satisfaction. CGM Kujbihar. 432 compliant. It is further ordered that the present accused petitioner shall appear before the learned trial court within 21 days. যেমন হয় certified copy or server copy.
জানো তো?
Wait for it.
জানো তো? না।
হ্যাঁ, তাহলে পুরো দাও, কবে চেয়েছিল?
There is no CD.
Wait is
Wednesday.
54,
12th.
55,
Wednesday. 56.
Same,
সবগুলো
57,
same.
I'm for the statement.
Wednesday.
Wednesday.
I'm for the statement.
Take microphone there. You are not audible.
Hello, calculation number 498, 825, and hello,
313. Who are you?
But this is my lord.
313.
I am for the mother-in-law and the brother of mother-in-law. There are no connection between us.
Rather of mother-in-law.
We decided at different places, and the residents will not say that they are falsely minor petitioner. Separate one thing, minor. Earlier one met, she was married, but and he house into separate matter. And this fact, like in Calcutta, and then people thought there is nothing minor getting here.
Is there any material to attract 313?
Yes, madam.
Page,
The report of Dr. Manoshish Barman, page 20,
page.
20, madam, 20.
Madam, already grant condition built from one matter.
আঘাতজনিত কারণে নষ্ট হয়ে যায়।
My lord.
Where is the medical examination?
Madam, at page 1616.
Before the doctor any name of the assailant has been given. History of physical assault is there.
16.
This 20 to the attending doctor নাম বলেছে। Physically assaulted by Robiul Islam.
Yes. Physically assaulted by
Who is Robiul Islam?
Ubaydul Islam.
Is the husband?
No, madam.
Husband is
Husband, madam.
Rahul Mia, husband.
Sahana and Chaidul. Sadul Singh.
Chaidul is mother-in-law's brother.
Mother is her brother.
Mother-in-law's brother.
Is there any 164?
No, madam.
Who is Shana?
Shana is mother-in-law.
In the affair, she stated that altogether they are tortured upon her, both physically and mentally.
due to more dowry. And forced her to work at Idbhata when she was pregnant, carrying 3 months only. And she denied and disputed it.
Then who is Rabiul Islam?
Rabiul Islam, the brother of mother-in-law.
He is not one of the petitioners. Shahadul Sheikh, Shahidul Hussain is the brother, you said.
Rabiul? শ্বশুর জাপতালি মিয়া আয়না বিবি ফাতেমা বিবি নানু কুরবানো বিবি জাপ জফিকা বিবি মামা
তিন হচ্ছে
আসামি ছাইদুল রবিউলের নাম ছাইদুল হোসেনের নাম এখানে আছে রবিউল and ছাইদুল is the same person?
No, my lord. Shahidul and Shahadul same person.
Shahadul and Shahidul same person.
এখানে তো কোনো নাম পাচ্ছি না রবিউল লিখলো কেন?
রফিকুল ইসলাম রফিকুল
Rafiqul is Rafiqul. Who is Rafiqul then?
Rafigul to be on also.
নুরবানি মানে 21 number 4 নুরবানু বিবি ওয়াইফ অফ রফিকুল
The allegations are under sections. You correct the first page. You have said 468A. 498A oblique 325 IPC stop. Subsequently, section 313 IPC was added. Stop. The petitioners are the mother-in-law and her brother. Mother-in-law of the victim.
এই বাবা
Is he বন্ধ করে দিয়েছেন?
আমি বললাম
Mother-in-law of the victim and her brother.
may I
ঠিক আছে?
may I Rafiul is the husband of Nurbanu, that is accused number 4.
he is not the petitioner.
No, he's not. Stop, they pray for anticipatory bail. Stop, they say they have been falsely implicated. Stop. The petitioner number 2 does not reside in the same house as the victim.
Sure.
Stop. They have no role to play in the alleged incident. Paragraph, the state opposes the prayer for anticipatory bail. Investigation is going on. Stop. Paragraph, we are told that charge sheet has been submitted. Stop. We have also seen the material in the case diary. Stop. We do not find, comma, prima facie, comma, any such incriminating material as would justify custodial interrogation of the petitioners. Paragraph, accordingly. Such and such usual. Anticipatory.
Charge sheet submitted.
Yes, my lord.
10,000 with 2 registration account. Satisfaction arresting officer 432 compliant. Appearance before the learned trial court within 21 days. Certified copy of uploading of the certified copy.
Get for us.
Similar footing.
Mob attack, lordship.
Give us those orders. The petitioner.
Lordship, almost all the sections of Indian Penal Code have been. Almost all the sections of Indian Penal Code.
Yes, the.
It is out of the same case.
Same case.
Item number 60.
Next circuit. 60.
Order prohibited on the prayer made on behalf of the petitioner. Let this matter be listed before the next circuit.
61.
Lordship, Tuesday, Lordship.
Tuesday.
62.
62, my lord, kindly make it on Monday, my lord.
Tuesday.
Tuesday.
63.
63, my lord, case diary is not available, my lord.
Wednesday.
Tomorrow I am going to Calcutta for my mother's operation.
Wednesday. The virtual link gave you.
64.
Grateful, your lord.
Each of the allegations were taken one of the reporter of the present ruling party. But Arijit opponent party supposed that they have handshake and vandalized the party office. The weekly complaint contains total 18 accused persons. But the narratives of the complaint very significantly specify is the FNM accused person number 1. But I am standing on serial number 8.
Investigation is going on.
Lordship. Investigation.
What do you say? Why do you need custody? Anything specific against him?
No, Lord.
Political rivalry.
What is the nature of injuries there?
Injury report is not there. That is why I have underlined the scan report, Lordship.
Where is the scan?
Nothing found in the brain parenchyma. Kindly note, Lordship, that I could not produce the injury report in the city.
The petitioner says that the incident was an outcome of political rivalry. Stop. Out of 18 accused persons, he is the number 18. He is at number 18. Stop. The main allegations are against the accused number 1. Stop. He has practically no role to play in the incident. Stop. He prays for anticipatory bail. Paragraph. The state opposes the prayer. Stop. We have paragraph. We have seen the material in the case diary. Stop. There is no such material, prima facie, as would justify custodial interrogation of the petitioner. Stop. Petitioner, so long as he cooperates with the investigating officer. Paragraph accordingly.
Okay, let him meet the IO. Once in a fortnight, meet the IO. Once in once in a fortnight.
5,000 with 2 digit of like amount. Satisfaction, arresting officer, 430 to comply. Is further ordered that the present accused petitioner shall meet the investigating officer of this case as and when called for. Till submission in final form.
কত করে দিবে? 7-8 স্বাক্ষর দিবে।
65.
No signature. No signature.
Wednesday.
Password matter item number 19.
কত নম্বর?
Track report, you would have the track report.
19. 19.
Not if service not complete. Next circuit.
Next week.
Wait, then Wednesday.
I have not
Wednesday.
received the CD. Yesterday I received the briefs, lordship. I have not received the CD as yet.
Wednesday?
Lordship.
Item number 20.
This is for you.
হ্যাঁ, ফার্স্ট ফ্লোরে ছিল না?
State
ইয়ে হদি?
20, my lord, state.
এই আসুন লিখুন। Yeah. 20,
20 not today.
not today, but Tuesday.
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 Item 24.
আসুন, 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 আসুন।
এসো, ছিল না তো বাবা?
না,
In the first call, nobody appeared for the petitioner, stop. In the second call also, nobody appears. Paragraph, the application being such and such is dismissed for default.
Item number 67.
66 ki at 4 PM.
Hmm.
All sides are there. So far as 66 item number 66 is concerned.
Oh, both sides.
Mr. Ganguly, it would help everybody concerned if we can take up 66 now. Today being a Friday. 66. Yes, yes. We'll be
Why not?
sitting. Why? Is there any
No.
request not to sit and only to stand? Friday. Very good.
So instead of 4 PM, it will be taken up at 2 PM.
No.
Maybe inform all concerns.
No, it is, other side is here. Item 67.
67.
Right. You are for the state. Private opposite party. No, there's a prayer for adjournment on behalf of private opposite party, whatever that means.
My lord, in this case, Mr. Sudeep Go is appearing for the accused
He
respondent.
is feeling unwell.
He is feeling unwell, my lord. Kindly make it not visible.
All right.
As your.
Next, on the,
As per request made at the bar.
as per request made by the advocates for the parties. Let this matter be listed before the next available circuit bench.
Wait for it.
68.
68, my lord, I am appearing for the state.
Next circuit,
Next. Like,
same order.
Yeah.
As per request.
Served. Served. Can.
If you want, we can.
But I am ready, madam.
Next sir.
On the joint request, made by learned advocates for the parties.
69.
69.
And for the state.
What the private of service complete? So what the service first. How many private opposite purchases are there?
Hand service or post? Track report is there.
One is item delivered and one is item dispatched. No. देखो. Why 3 track report then when there are 2,779
The last update,
item delivered 779. দেখুন এটা item dispatch হয়ে আছে তাহলে এখানে item delivered address or item dispatch.
Item dispatched. Yes. No, no.
I have marked it one in blue pencil and another is red pencil. How many opposite parties are there? Two.
State actor to appear.
there are two opposite parties in the track report. So, the track report shows that I can deliver.
In respect of one. In respect of one consignment, it has been delivered.
No, madam. So, there are two separate tracking items. Can we have a two?
ID is one is 779. Okay. 5513 item delivered. And which one? What is the third one?
That was the one
Previous.
the last update.
What is your grievance? What is the order? So as fast.
Anticipatory bail.
Cancellation.
Yes,
So
cancellation.
what was the cancellation of what bill?
Anticipatory.
The allegation was under POCSO Act.
No, just tell me. Tell us one thing. Which order you intend to cancel?
Under the order dated 31st of September 2020.
October.
October. As passed in CRM in 440 of 2022.
So what terms and conditions was imposed by the special judge?
But that was passed with the 48.
Page.
By this order,
There being no allegation against the present petition under section 6 and 17. It was considered favorably.
I have a report page 18 of my application.
18 is the
The forwarding show where from it reveals the surprising. First minute finding is on page 2 is one. The field is the complaint that was lost by one Vinod Gordon. For whom the bail, anticipatory bail was granted.
It's 12.
He was the.
আমার তো 12 ওটা আমারটা কত 11
11.
The main allegation is against the Konok Bormon.
Is Vinod Korman was the de facto complaint. When the verities of the complaints, reveals that, এমনিত নিবেদন এই যে আমি একজন উপযুক্ত বিছানায় স্থায়ী ও শান্তিপ্রিয় বাসিন্দা আমি এই কর্মে আপনার জীবন এটা একটা পরিস্থিতি আমার সম্পর্কে
Which page?
Page 11.
Page 11.
Don't disclose the name of the guard.
সম্পর্কের আত্মীয় শোভন বর্মনের নাবালিকা কন্যা পাচার করে স্বাধীন পাচার কোচবিহার তাহার আপন তীর্থ দাদা অর্থাৎ একজন আসামির সহিত তাহার ভালোবাসার সম্পর্ক ছিল সেই সম্পর্কের কারণে একজন আসামি তাহাকে বিয়ের প্রতিশ্রুতি এবং নানা সময় নানা প্রলোভন দেখিয়ে তাহার ইচ্ছার বিরুদ্ধে তাহার সঙ্গে সহবাস করে যাহার কারণে সে গর্ভবতী হয়ে পড়ে এবং একটি পুত্র সন্তানের জন্ম দেয় যাহার বর্তমান বয়স 3 মাস কিন্তু বর্তমানে একজন আসামি তাহাকে স্ত্রীর মর্যাদা এবং বাচ্চার পিতৃ পরিচয় দিতে অস্বীকার করে পরবর্তীতে গত 17/3/2022 ইংরেজি তারিখে সকাল অনুমান 9টার সময় সে তাহার সন্তানকে নিয়ে 1 নং আসামির বাড়িতে গেলে সেখানে 1 নং আসামি এবং তাহার পরিবারের অন্যান্য সদস্যগণ তাকে মারধর ও গালিগালাজ করে বাড়ি থেকে তাড়িয়ে দেয়।
This is the written complaint in respect of other case.
No, my lord. Is Vinod Korman, my lord, being the de facto complainant, my lord, filed his complaint on behalf of his, my lord, near relative.
That was registered as PS case number 195 or 196 of 2022. Huh.
196.
My lord, most surprisingly, thereafter, my lord, it reveals that these Vinod Korman and his son are, my lord, the main actual participators who committed the rape and, my lord, ravished the victim girl. And thereafter, the victim girl, my lord,
Where is the second FIR?
my lord, kindly have a look on page 18.
18.
18 is the, my lord, the forwarding letter from which, my lord, this fact, my lord, came into light.
I don't have 18 here. It is compliance report. We have filed. Clear. Clear. 17.
What is it? Is a compliance report of what?
No, page 17.
17.
17.
That's the dispute.
Keep of you party, my lord, there is a, my lord, fifth in the petition.
17.
17.
Say like that. Page 17.
Page 17, but that is the third paragraph. That is the forwarding letter.
Hmm.
May
Hmm.
However, according to the judicial statement, according of the VP statement that the main culprit is one Dipankar Bormon, son of Vinod Bormon, within brackets the complainant of the case. Dipankar made a love relationship with her and sexually assaulted her several times, resulting in which she became pregnant and gave birth to one baby boy. So, hence I examined her once again and she stated that as she was living with the family of Vinod Bormon, all of them which includes the main activist Dipankar Bormon, this married. His sister Dipali Bormon physically assaulted her on daily basis from the time of her pregnancy to the date of the FIR registration. They mentally pressurized her and manipulated her in believing that if she takes the name of Konok Bormon, son of Monu Bormon of such and such, Kochbihar, he will take the responsibility of her child. Stop. Giving her continuous life threat to not to disclose the name of Dipankar Bormon and his family members who are the main culprits. The victim girl also stated that Dipankar Bormon sexually assaulted her in his house at such and such. This is also to note that all the involved accused persons are permanent residents of Dipankar case area. Also other examined witness stated as the above. As the PO of the case as the accused person all
Is there anybody on behalf of the private opposite party? What do you want to say?
I want to say, madam,
one coordinate bench of the Honorable High Court, after considering the material that we are allegation.
Just a minute, you are submitting on merit. You are submitting on merit. Submitting on merit. Wait for some time. We will hear you.
শুনিনি কি করবো
Page 16, my lord, that is another forwarding link.
16
Page 15.
15.
একটু করে নিয়ে use করবি
Huh.
Second paragraph. Your permission, my lord, may
120 বিলা
issue. From the second paragraph. During investigation of the case, LSI Vili Shindho of Mathabanga PS has examined the complaint and PG and recorded statement under section 161 CRPC of the VG and forwarded the VG before the Mathabanga MD hospital for medical examination of the minor. Medical examination of the VG is done and LSI Vili Shindho corrected the medical examination report along with OG container of the vaginal swab and such and such arrested the offending accused person, Monu Gormu, such and such. And forwarded before the learned court same day. And same day forwarded the minor VG before the learned court for recorded official statement under section 164. Judicial statement of 164 of the minor VG is done and also examined the available details and recorded their statement under section 161. CRPC stop. Then on 4th of April 2022, one Shobhendranath Borgon, here I will call this Shobhendranath Borgon, my lord, happens to be, my lord, the father of the victim girl, who, my lord, later on, my lord, filed the complaint, on the basis of which, my lord, this fact remains that the original culprit is, my lord, the de facto complaint.
That has been registered as?
My lord, here, my lord, I will come on this.
Yes.
Then on one Shobhendranath Borgon, from such and such, because we have further laws the written complaint before the IC Mathabanga is 5 Mathabanga PS GD number such and such. Then as per the learned court order, LSI Nimishino handed over the original case docket before the OCPS and as per the endorsement of the OCPS, LSI Shomita Roy took up its investigation. Stop. During investigation, previous IO, LSI Shomita Roy, visited the PO and prepared draft sketch map of the PO and examined available witness and also examined the minor VG and further recorded her statement under section 161 CRPC of the VG. During investigation of the case on 10th of August 2022, arrested the accused person, namely Shonjit Roy, such and such, and Ukil Bormun, such and such, and under proper memo of arrest and forwarded before the learned court below of the same day. During investigation, evidences have been collected against the above noted accused person. Stop. Then due to transfer of the previous IO, LSI on 25th of August 2022, handed over the original case docket before the OCPS and as per endorsement of the OCPS, LSI Parthopratim Roy took its investigation. During my investigation, I further visited the case and examined the complainant, victim and other witnesses who were recorded by the previous IO and found all the same. So I did not record their statement separately. During investigation, as per the admission of the VC and as well as the local witness, it could be ascertained that the original culprit of this case is the son of the complainant, namely Dipankar Borgon. Here is the complainant, my lord, that
Father of Dipankar.
As per the VG statement, it was found that Dipankar Borgon sexually assaulted her several times at his house with the knowledge of his family members and relatives. Stop. The actual accused person's father named Shinonath Borgon, who got bail, who got an bail, son of Sergeant conspired and threatened the minor VG and convinced her to lodge a false.
We understand. What is the FIR of the second case?
FIR of the second case is filed, my lord, by the father of the de facto.
What is the case number? What is the PS case number?
That was the 1 minute, madam.
Yes.
In this case, my lord, order challenged by one coordinator. Suppose for me, if your lordship refuse my welfare, where is I go? I go, it would be higher for. If one cancel, one bail was anticipated, bail granted by the honorable high court. It must file before honorable.
No. That is not the statutory provision.
No, madam. one coordinate bench and one merit, this order was passed, my lord, it cannot be maintainable.
It can be.
Even,
Bring the decision at 2 p.m.
even 413 and 2 can be cancelled by the same
Ah,
judge.
same judge.
Correct.
Even if, you know,
This is a sharp with the what you say.
same.
That will be-
Cannot be. It's unheard of.
Close the contact.
If it is found that the bail order has been obtained by practicing fraud upon the court,
Yes.
suppressing the bail order, the court cannot. Then no decision is required.
Order passed by the Honorable High Court, my lord.
No, don't go into the merit. Yes, please let him finish. Yes. Oh, time. The time is up, come at 2 p.m. Yes. Judgment, tell us one thing, that when the order under challenge was passed, this factor was not placed. No, just a minute. So far as the first complaint is concerned, another person was implicated at the instance of the present opposite party number 2, isn't it? For which Matavana PS case number 145 of 2022 was started, isn't it? Now, tell us one thing, and the bail order was granted in connection with 145. Now you said subsequently it reveals that the main culprits are the opposite party number 2 and 3, upon which PS case started.
Father of the mother victim
Huh.
logs the complaint on 4th of April 2022.
Where is that? That we intend to see.
That I tried to obtain from the police station as well as from the court, and it was not handed over in spite of brilliant case report. It could not be obtained. It was only the reference has come out from the forwarding date.
Learned counsel for the state, you can assist us.
When the bail order was granted is 6/9/2022.
Yes.
Lordship, the statement, subsequent statement was recorded on 30th March 2022.
Just tell us one thing. Whether any subsequent PS case was started or in the same case, the accused has been changed.
Basing upon the statement of the VG,
Accused has been
Accused has been
changed.
changed.
Oh, that I intend to say.
subsequent statement.
So give us the same. No, we have to see when this order was passed, that statement was there or
That
not.
was there,
But it was not placed.
not placed. Lordship says page 83 first. Kindly page 83. Page 83 is the order. Final order is 85. 83 is the order.
83 is the order of
CRM anticipatory 440/2022 dated.
So it was not disposed of.
No, second is 85. 85 is disposed of.
It was dated 31/10/2022. Now, when the order was, when the
Statement.
actual, according to the prosecution, when the actual state of affairs come
Lordship.
into
Page 23. 31/10/22 and now sees page 23.
page 23.
164, second 164 of the victim girl.
Page 23.
23. This is the second statement.
It was recorded on,
Lordship, March 30th March 22.
and the order was passed on
First order was passed on
30th March 2022.
Lordship, the statement.
But the order was passed on later.
Lordship. But those were considered as because the victim changed her version. There were two 164 statements.
First one, 61.
First 164 statement is 28 March 2022, page 5. Page 5. But this is page 5.
Here the allegation is against Konak Borman.
Konak Borman, page 5. Page 5 of the case study. 164 statement recorded on 20th
But
March
here-
2022.
She named the
Dipankar.
Borman.
Dipankar. And she stated that she was compelled to.
Where is the first statement?
Page 5, Lordship. So the second statement may be afterthought, maybe due to pressure, whatever reason may be, but completely the scenario changes. In first statement, she named someone else, and second statement, she named someone else, stating that I was compelled to make this statement. So the court took it either way, because it cuts either way. Lordship knows better than me that it may be afterthought, gained over, or what she is stating regarding threat. Both can be possible.
In this statement, it's a first. Oh no, if I am in the second statement, against the point, and is father. মানতে পারে কি আমাকে দাবি করে দাবি দিয়ে আমার থেকে ধর্মের বিয়ে হয়নি and এভাবে আমি আমাকে বিয়ে করে নেপাল নিয়ে এখানে নাম দাবি দিতে গলা গেল it was recorded on 30th March 2022. The order was meant to have been set aside. ওটা হচ্ছে 31st October 2022. And it can be presumed that when the order was passed, nothing was taken into consideration. Tell us one thing, when this order was passed, the second statement was very much in the city.
Yes.
Then how can you, on what score you want the recall of that order or modification of the order or cancellation of whatever you like?
Past 164 statement was my lord given, my lord, I presume that so far my instruction.
No, come to point. According to the first statement of the victim, she mentioned the name of the FIR named accused person. Am I right? In the second statement, as recorded under section 164, she mentioned the name of the opposite party number 2 and 3. Am I correct? When the order which you are challenging or you intend to cancel, that was passed much after the recording of second 164.
Lordship.
So how do you say that it was suppressed or something like that?
But the past statement, my lord, was my lord obtained, my lord, when the victim, my lord, stated the 164 statement at the first instance, immediately after lodging of the first complaint, my lord. She was under threat and inducement.
We appreciate. But when second statement was given, he was not under threat or inducement. For the sake of argument, we accept that this second statement is primarily correct. Even then, the order was passed much after there. Then on what ground you want cancellation?
Lordship, kindly see page 13 and 14. This is very vital, Lordship.
Statement 164.
13 and 14.
Why it would have been produced before
Court cannot act upon ifs and buts.
Your Lordship, their allegation is it was under threat, first one. But court took that two views are possible. And Lordship knows that either way it cuts. It may be afterthought also. It may be gained over also.
34.
13 and 14, medical. Where the opinion of the doctor is very vital. History in brief, back page of the report, opinion of the doctor. Clearly says without any force. Should have consenting. That means if Dipankar is the accused, if you, for the argument's sake we take it that is this child of the Dipankar, it was consenting. No forceful act was there.
This cannot be done. If we do this, it will open a floodgate. Be that as it may, that has been considered. If you agree, go up. There, you cannot plead that there was a suppression of material fact or it was fraud was exercised upon the court. It's not so. Much after recording of the second statement under section 164, the order under challenge has been passed, isn't it? Then come.
That might not have been produced
We cannot speak.
Sir, we cannot speculate. This order was passed much after, as my lord is saying. So we can't speculate.
Yes, Ashok.
It would be improper on our part. Coordinate bench.
There be some stringent conditions.
That can be.
That can be.
That can be.
Yes.
This is an application under section 439 within bracket 2 of the Code of Criminal Procedure, whereby and wherever the petitioner has prayed for cancellation of the order of anticipatory bail as passed in favor of the opposite party numbers 1 and 2 on 31/10/2022. No, they are paid for cancellation. As passed on 31/10/2022 in CRM A 440 of 2022 by a coordinate bench of this court. Stop that. Learned advocate for the petitioner in course of his submission draws attention of this court to the written complaint as filed in Matavanga PS case number 145 of 2022 dated 28/3/2022, wherein one Konok Bormon was arraigned as principal accused. Attention of this court is also drawn to Annexure A2 at page 15 of the instant application, wherefrom it reveals that in course of investigation, it revealed that the main accused is one Dipankar Bormon, who happens to be the son of the present accused, present opposite party number 2, isn't it? And brother of opposite party number 3. Brother of opposite party number 3. Stop. It is contended on behalf of the petitioner further that such change of circumstances probably was oblique were not placed before the coordinate bench on 31/10/2022, which is why a favorable order of anticipatory bail was passed, full stop. Learned advocate for the petitioner thus submits that in view of the changed circumstances and in view of non-placing proper materials before the aforementioned coordinate bench, the anticipatory bail as passed on 31/10/2022 in CRM A within bracket 440 of 2022 may be cancelled and oblique or recalled. Stop. We have heard learned advocate for the state as well as learned advocate for the opposite party numbers 2 and 3. In course of his submission, learned advocate for the state candidly admits that in our initial statement as recorded under section 164, a page number, as recorded on just a minute. As recorded on 20th March 2022, the victim has mentioned the name of the FIR named accused person, accused number 1 as the principal accused, whereas in her second statement, as also recorded under section 164 CRPC, page number, whereas
second statement recorded under section 164 CRPC.
On 30th March 2022, the victim has mentioned the name of the son of the opposite party number 2 and the brother of the opposite party number 3 as the principal accused, wherein also there are several allegations against the opposite party number 2 and 3. Stop. In our considered view, when the coordinate bench passed order on 31/10/2022 in CRM A 440 of 2022, the said coordinate bench has definitely perused the entire materials as placed before the said bench, and nothing could be placed on behalf of the petitioner that the second statement of the victim dated 30th March 2022 as recorded under section 160 of CRPC was suppressed before the said coordinate bench. Stop. Such being the position, and keeping in mind the judicial propriety, we are convinced not to interfere with the order under challenge stopped. As a result, the instant petition fails and is hereby dismissed. Yes. However, page ফাইলটা কোথায় ফাইলটা কোথায় গেল ফাইলটা কোথায় গেল page 29 of what?
Further investigation. Further investigation.
Which portion, sir? Which portion?
Order dated 17th May 2022.
You have to hand over the entire case over to
The IO SI Mimi Singh Mathavanga is directed to hand over the entire case dockets to the OC Sidalkuchi PS for further investigation. 173(8) CRPC. 173(8).
What do you want? No, that we cannot do here.
Court cannot.
No, go to there.
Lordship,
Yeah, we can, yes.
Upon receipt of new facts, the police can start further investigation without even the order of the court.
It is however ordered that the present opposite party number 2 and 3 shall not leave the territorial jurisdiction of the learned trial court. Charge sheet not submitted, no?
Lordship, Lordship.
Have not a separate investigation been ordered?
No, Lordship.
Shall not leave the territorial jurisdiction of the trial court and shall meet the investigation, shall meet the investigating officer of this case. Na kore lekho, meet the investigating officer of Mathavanga PS case number 145 of 2022, dated 28/3/2022. Till submission of final form and the present opposite party number 2 and 3, they reside in the same area.
Same area.
Yes, my lord.
They shall not commit any threat, hand of legal inducement either to the victim and or his family members.
Investigation has been transferred to Jalpaiguri police station. Right. But I think the action will be passed to meet the IO. It is the jurisdiction of
It has been transferred.
Lordship, actually the accused changed.
Order is concerned, my lord.
The accused has changed. The second accused is a resident of
তাহলে
Sidalkuchi. So
Sidalkuchi
I'm going to
কি লিখলাম ওটা? To meet the shall not leave the territorial jurisdiction of the trial court and shall meet the না আরেকটু আগে আছে একদম অতটা যাবে না, লাস্টের দিকে যাওয়া একদম ওই যেখানটা পড়লেন তার উপরে of Jalpaiguri PS case number.
Lordship, the same case has been transferred, but our case diary, but we have to see it.
Kindly have a look on page 29 of the learned.
এটা also
29?
what is the case? Jalpaiguri PS case.
The investigation has been now transferred to the Jalpaiguri PS police station. But as per the learned court below, page 29. So if your lordship pleases to direct the accused person to meet the IO, that would be my lord to the accused person will also have to meet with the IO.
What we are asking, has it been assigned a new number after being
No,
transferred?
Lordship, as per the case diary, still is Mathavanga PS.
Mathavanga PS. But we report করতে বলছে এটা চিতলকুচিতে ট্রান্সফার করে দিয়েছিল।
That order has been completed.
To the investigating officer of Mathavanga PS, Mathavaanga PS case number or to the IO who is at present, or to the IO of the concerned PS who is at present dealing with this case. It is sufficient.
If it is transferred, then we will meet that same person. Yes, Lordship.
Learned advocate of the state is hereby requested to communicate this order to the concerned IO for his information and record.
Lordship. Section number.
আচ্ছা এবারে ওইটা দিয়ে দিন স্পেশালিটিস ম্যাটার
একদম
ফাইলটা কি হলো এই ফাইলটা আমাকে এখানে দিন যেটা উকিলবাবু দিয়েছিলেন ওটা খুলে আমাকে দিয়ে দিন
আমারটা আছে
বলবি তো কিছু নাকি বলবি তো আবার
কি করতে বলছি না বলছি কেসটা তো ভিতর থেকে কোট করেছে
আটটা নটা কনভেনশন করছে এবারে আপনি চলে আসুন না at least in 2 or 3 cases, followed the principles of law as enunciated in the DK Basu case. And it has been held by the coordinate bench that in the event arrest memo is found to be blank and in absence of proper explanation, it will presume that the arrest is not genuine. So the court can consider that the restriction of 37 of the NDPS Act can be overlooked because it presupposes the innocence of the accused, and it also presupposes that the arrest is not proper and genuine. This is the main thing which we have understood. If you want to add, you can add.
And family member is not there.
So give me the file then.
Here's the memo, column there of-
It is 490.
66.
66 amount. 66 amount.
Yes. Let us take the 66 one by one.
All right.
So far as 66 is concerned, what is your contention, ma'am? Signature is blank. This one.
Arrest has been occurred during 6 PM. Lordship, then it is so many persons that there. Lordship, the name of the single independent witness signature may be taken up, but Lordship, there is a signature of the police person. No respectable person of the society or independent witness or any family member of this arrestee signature has been.
Signature of whom is there? LC Romanan.
Lady Constable. Lady Constable.
Okay. This is your contention.
Because she is the petitioner here is Minoti Roy is a lady. So the Lady Constable was there.
Where from the arrest was conducted?
From Lordship Madari Toll Plaza.
Place of-
Kochi Madari Toll
place of-
Plaza.
Madari Toll
Toll
Plaza.
Plaza. In National Highway.
It is not a deserted place.
No, Lordship.
Then how do we explain?
I'm not. Lordship, this is admitted fact that Lady Constable signature is there. Anything else? Okay. Please allow to make my
Yes, sure,
submission.
sure.
Lordship, I will certainly not state anything which goes against the principles of our guiding principles of DK Barshu or constitutional bench or law. What I would like to place before your Lordship is that whether not only 41B, any provision of the Code of Criminal Procedure, I am taking the picture, big picture, looking at the big picture. Any provision of Code of Criminal Procedure is a sine qua non in a case of NDPS Special Act. I'm taking my argument on that point. If Lordship pleases after my submission that yes, special statute and special findings has ought to have been given, then not only 41B, any provision of Code of Criminal Procedure will be set aside. Now, Lordship, before I start, why I'm saying so, the NDPS Act, I would like to, your Lordship knows, but for my satisfaction, I would like to place the thing.
Proceed.
NDPS Act is,
Sorry, before you proceed, Mr.
Sure.
Langli. Justice Topobruto Chakraborty's judgment, the coordinate bench, that was also NDPS.
yes, Lordship, I'm coming to that.
Now, the
But-
problem is it's a coordinate bench.
Lordship, in that case,
Even if we agree with you, we might not,
a larger bench than Lordship.
we keep that in mind.
I'll give another coordinate judgment where 7 of these type of judgments were placed, but the bench turned down their petition on basing upon my submission.
In that judgment or those judgment where DK Basu's judgment was considered or not, that is to be looked into.
Yes, Lordship.
One thing that is matter, item number 30 was tagged with item number 66 matter because.
We'll hear you. What? So Hari, down 235, code is 430.
Lordship, NDPS Act is not a national act. Why I'm saying so? It has a special preamble behind it. There was a single convention of narcotic drugs in 1961 in UN. During the 60s, the drugs use increased greatly around the world. The single convention of narcotic drugs of 1961 could not ban mainly new synthetic drugs which were coming into the market at that time. Because prior to that, the 60s, we know Che Guevara and other rock bands and other thing, everyone, cannabis and opium, those were the narcotics found in the market. Even in India, 1930 Dangerous Drugs Act, 1878 Opium Act, it was within the periphery of this opium and cannabis. But subsequently, the synthetic drugs during the 60s came into the market. And it became a great concern in the entire world, not only in India, because at that time, India was not the part of that treaty. It became a great concern in the world that it has to be stopped, because the preamble says, that convention preamble says, if a person commits murder, he kills 1 or 2 persons. But if a person commits a crime under NDPS, he is killing the entire society, the entire future of the society, and the economy of the state. So it has to be given a strict jacket formula to obtain bail. Lordship, at the time that 1961 convention was there, subsequently another convention of psychotropic substance. The first one was single convention on narcotic drugs, which was not covered at that time because synthetic drugs were coming. Psychotropic substance. Convention on psychotropic substance was held in 1971, designed to control psychotropic drugs, was signed in Vienna, Austria in 21st February 1971. Subsequently, following the protocol of 25th March 1972 at New York, on 8th August 1975, in accordance with the Article 18 of the Protocol of 1972, the Single Convention of Narcotic Drugs 1961 was amended, and 186 countries gradually signed that treaty. So this act is not regarding India, it is regarding the nation, United Nations. 186 countries signed that treaty. They pledged that stricter act should come to stop this menace. And Lordship, India signed the treaty on 4th December 1978. Till that period, there were acts which I stated to control narcotic substance in India, that is Opium Act 1878, Dangerous Drugs Act 1973, and Drugs and Cosmetics Act 1940, which still prevails. But after signing the treaty in 1978, the Opium Act 1878 and Dangerous Drugs Act 1973 got repealed. A new act came into the market, into the our permanent purpose, that is Narcotic Drugs and Psychotropic Substance Act 1985. After 78, 85, it came into the form. But still, the drug rackets could not be controlled, as because taking advantage of various provisions of the Code of Criminal Procedure 1973, the peddlers were getting enlarged on bail. Several amendments were made in the Act itself, one of which was insertion of Section 37 NDPS Act, which was introduced by the Act 2 in 1989. The treaty was signed in 1978. The Act came into force in 1985. But Section 37, excuse me, sir, please. The Act, Section 37 was introduced in 1989. That is 29th May 1989. So the intention of the legislature was that to make the bail stricter. Section 37 of NDPS Act, it starts with a non-obstance clause. Notwithstanding anything contained in the Code of Criminal Procedure. So whatever is there, The term notwithstanding means in spite of, despite, nevertheless, although. Whatever is there in Code of Criminal Procedure. Section 37 NDPS Act prevails over it. Notwithstanding anything contained in the Code of Criminal Procedure, entire Code of Criminal Procedure. Now,
No, when it is applicable to all the laws. When
Yes.
there are general laws and there are special laws,
5 savings.
special laws always.
All the prevail. But this, obviously, yeah, I'm grateful, Latif. I'm grateful. But this section starts with a non-obstant clause. Notwithstanding, I am only confining my submission on 37. Notwithstanding anything contained in the Code of Criminal Procedure.
In the Code of Criminal Procedure pertaining to grant of bail.
Yes, Lord.
If
Yes,
we
Lord.
read that.
Yes, Lord. Yes, obviously, 167 and then 439, 438, 437. Now, scope of 37. Contemplates that before passing any order, releasing an accused on bail, the public prosecutor has to given an opportunity to oppose the application for such release. And where he opposes. So, in my humble understanding and little understanding of law, where he opposes means where the public prosecutor does not oppose, section 37 not applicable.
Body is not applicable.
Body is not applicable. Where he opposes, it is required to the court to be satisfied that there are reasonable grounds for believing that the accused appellant is not guilty of such offense and he is not likely to commit any offense while on bail. Now, Lordship, I come to section 5 CRPC. Lordship knows that the special act will prevail over general this thing. This means that a CRPC with its provisions is not applicable where any different procedure has been prescribed by the law. Since the Act prescribes a separate provision for bail, the general provision under the CRPC will not be applicable. The Act has been enacted with a view to make stringent provision for the control and regulation of operation of relating to narcotic NDPS. Now, Lordship, DK Basu's judgment. They are giving it. Lordship has seen the judgment. Mainly, the judgment is relating to 1997 1 SCC 416. DK Basu's judgment. Lordship, my having it. This is mainly infringement of fundamental rights guaranteed under Article 21 and 22 of Constitution of India. It was decided on 18/12/1996. Now, my submission is whether section 37, the rigor of section 37 can curtail the right under Article 21 also or not. I'm coming to that point. DK Basu's judgment is regarding the police, the custodial torture, so on and so forth, and it has been circulated amongst the courts to follow those things, CRPC, mainly Article 21 and 22. At this juncture, Lordship, I would like to place a reliance upon a judgment reported in 2023 SCC Online, Supreme Court 346. Here देबो रिफरेंस लिखे ना मैं बोर्ड दीची 346 Lordship, para 5.
Just a minute.
Here also the bail was granted. Para 5, Lordship. The bail was granted in support of another constitutional bench judgment of Satyendra Kumar Antil versus CBI. The respondent, I'm reading, Lordship, para 5. The respondent accused has been directed to be released on bail by impugned order, keeping in mind the large mandate of Article 21 of Constitution of India. In the light of the decision of this court passed in 11/7/2022 in Satyendra Kumar Antil versus Central Bureau of Investigation in SLP criminal such and such, reported in 2022 SCC Online, Supreme Court 825. Mainly for the reason the main accused person Om Prakash Jadhav and Amit Jadhav has been already released on bail. Now, Lordship, this is also another judgment which was the bail was granted following Article 21 of Satyendra Kumar Antil. Now, Lordship, I kindly take your Lordship to para 14. Para 14. Regarding the case, then, this apart, It is noticed that the High Court, in passing the impugned order of bail, has lost sight of Section 37 of NDPS Act, which inter alia provides that no person accused of an offence involving commercial quantity shall be released on bail unless the twin conditions laid down therein are satisfied, namely the public prosecutor and the twin condition. So, even and the bail and para 16, the bail which was granted by the High Court was cancelled. So, what I submit, even if the High Court granted bail following another constitutional bench judgment under Article 21, observing right to life and liberty, but in spite of that, Supreme Court says, while granting bail in NDPS case, Section 37 has to be diluted because there's a special statute, rigor is there. Even if Article 21, the bail was granted under Article 21, but it is noted that the High Court, in passing the impugned order of bail, has lost sight of Section 37. So 37 has to be considered while granting bail in NDPS Act.
Mr. Ganguly, just thinking aloud, it's like an academic discussion. now.
Lordship.
Where from would you ascertain whether commercial quantity is involved or not? Prima facie from the Caesar list.
Caesar list.
What happens if there is some irregularity in the Caesar list?
Yes, then bail will be granted. But here, no Caesar list, there is no dispute in the Caesar list. Anybody witnesses are there. What I submit, rightly pointed out.
If in the Caesar list, you can secure the signatures of the independent witnesses, then what
Lordship.
prevented you?
Yes, Lordship.
What prevented you?
Their signature.
Signature-
Yes, my point is, in a case of this type, Caesar is made first and then he is arrested. Because
it's almost simultaneous.
so Lordship,
Don't, please, don't interrupt. After all, he's making an academic.
I'm not opposing your bill. This is law.
He is assisting us. So also you.
Lordship, in a case of NDPS where huge quantity is there, at the time of Caesar, labeling, it takes a lot of time. After completion of that, at the time of arrest, the signatures are taken. It is a national highway. I cannot say that, Mr. So-and-so, you wait for 4 hours and get the signature. Because if I take the signature prior to that, the date will be the same. The time of arrest and time of Caesar will be 2-3 hours late. But what they will say that the men were waiting for that.
National highway cars are running all the time. You could stop a
So
car.
it will be, Lordship knows Section 100 also at the time of arrest. No person.
I'm just trying to be difficult.
Is there reflection in the time? That it took time in seizing the
Yes,
article, so
if Lordship says the time of Caesar and time of arrest.
the explanation in the CD that for such and such reason, the gentleman's signature could not be obtained in the arrest.
In this present case, no.
Then
In this present, no. What I am submitting, this Caesar memo.
listen, in our adversarial system of justice, we have to follow some rule. When Supreme Court passes direction upon, High Courts are bound to follow that.
Lordship.
When High Court passes direction, trial courts are bound to follow that. So in this case, when there is a clear-cut judgment, it is binding upon not only upon the judiciary, but also on every citizen of the country.
Mr. Ganguly, sorry.
So the police authorities are not excluded from following the directions or guidelines of the
Obviously
High
not,
Court.
obviously not.
Whether that guidelines have been followed or not, that is to be looked into.
And I submit these points as because the Caesar, my lord, Justice Banerjee has pointed out that regarding Caesar. If Caesar is disputed, then the question of that can be, because if in a case where arrest is not there, but Caesar is there, even the case starts. Another judgment, Lordship, I'm relying
Mr.
upon.
Ganguly, again, before you go there, Criminal Procedure Code is procedural.
Yes, procedure.
Today, if NDPS Act prescribed or laid down certain procedure for executing a memo of arrest, that would have prevailed. No problem, notwithstanding, non-obstante clause. But there's nothing how a memo of arrest is to be. But therefore, CRPC will apply.
Yes, so CRPC will apply, but Lordship, I am relying upon another judgment, Lordship. reported in 1999 Supreme Court, 9 Supreme Court cases, 4-9, Union of India versus Ram Samuj and another. Narcotic Drugs and Psychotropic Substance Act, Section 37, 8-18 bail conditions precedent for grant of postulates in Section 37(1)(b) held are mandatory. Hence, in absence of satisfaction of the said conditions, the High Court order granting bail to an accused charged on an offence under 8 and 18 of the A held bad.
What were you reading? Which?
Head notes.
Oh,
Head notes, Lordship.
no, don't read head notes.
Oh.
They are often misleading.
Head notes are.
Lordship, it starts with para 5. The jurisdiction of the court to grant bail in is circumscribed by the provision of Section 37 of the NDPS Act. Now, Lordship, here we are discussing relating a point of grant of bail. It can be granted in a case where there are reasonable grounds for believing that the accused is not guilty. Now, Lordship, if the seizure list contains signature of independent witnesses, seizure list contains the signature of the accused, the seizure is established. As because during arrest, there are some
Procedural
lapses. Can this seizure, which has been established, and as soon as the seizure is established, Section 37 comes in. Had there been any dispute procedural lapse in the seizure list, I would have no case. Here, Lordship, it can be granted in case where there are reasonable grounds for believing that the accused is not guilty of such offence and that he is likely to commit any offence such and such. No person, 5 years. No person, 37(1)(b), no person accused of an offence punishable for a term in prison of 5 years or more, public prosecution such and such. 2. The limitations of granting of bail specified in clause B of subsection 1 are in addition to limitation of code of criminal procedure. It is in addition. So after following the CRPC, this has to be considered. It is in addition. Or any other law for the time being enforced in granting bail. This is the rider. Now, 6. Aforesaid section is incorporated to achieve the object as mentioned in the statement objection and reason for into a bill of 21 that 1998 there was a bill that is there. Now para 8 Lordship kindly sees para 8. Now I am concluding my submission mentioning that Lordship, this is a judgment of coordinate bench where I stood on behalf of the state. Where, Lordship, 3, I can add 5, 8 coordinate bench judgments were placed. 8 coordinate bench judgments were placed. But I placed these 2 judgments which I have placed before my lords. It has been page 3 of the judgment your lordship will get. And after considering the same, that 8 judgments, the bail were rejected by coordinated bench.
Page 3.
Page 3 is my judgments, which I have relayed today. On that day also I have given those judgments.
Okay. Similar point was there, is there?
Yes, similar. They have given lordship page 1, 3 judgments, and page 2, 5 judgments of the coordinated bench where 41B was considered.
And this bench relied on Ajay Kumar Singh? No.
No Ajay Kumar Singh lordship. Ram Samuj and Ajay Kumar Singh, both.
Ajay Kumar Singh is supporting your case?
Yes, I have given it, lordship.
Today?
Today. 2 judgments I have given.
Ram Samuj, yes.
Ajay Kumar Singh. So my submission is, lordship, when the seizure is established, section 37 comes in, and to grant a bail under section NDPS Act, 37 has to be diluted. Without curtailing the rigor of section 37, I humbly submit, Lordship.
So a defective arrest procedure will not necessarily entitle them to bail.
Bail, it can be taken up at the time of trial.
If the seizure is found to be
Seizure found-
parapsychic,
because Lordship knows better than me that not in a case of murder, but in a case instituted otherwise upon a police report and this type, like NDPS case, excise case, another case where seizure is the main, where no seizure, no case. If seizure is established, the rigors of 37 comes into play. This is my humble submission, Lordship. The pitch was very hard, the ball was bouncy. I tried my best to duck and place my case.
No, you did very well. You didn't even use a helmet.
Inspired by Gavaskar. Inspired by Gavaskar.
just a minute, one by one.
This will reserve the judgment,
Lordship.
Mr. Hon'ble, because this needs consideration.
Lordship.
Needs consideration. Either way, there's argument.
Lordship, I believe.
That during the time of marriage, the certificate of independent witness also.
Yes, Madam, the only thing in that judgment, 1985 Act was not under
Not
consideration.
NDPS.
It was not NDPS.
Not NDPS.
Whether a special act,
It was not about NDPS.
whether
It's general arrest. General arrest.
again, there will be another argument, Mr. Ganguly, the age-old argument that when a statute prescribes a mode of doing something, that something can be done by strictly following that mode or not at all.
Yes, Lordship. Yes, Lordship.
Taylor versus Taylor, Nazir Ahmed, 1936 Privy
Well,
Council.
Lordship, what I say that seizure and arrest. If my submission is if there is any difficulty in the seizure, I have no case. But arrest part at the time of trial. Even in NDPS case of Mohanlal judgment, it has said that to dispose of the property article 50 and other things.
If a judgment is reserved, a hearing is concluded.
On this point, my lord, item number 30 has also been tagged, my lord. I have not been granted.
Really? Your matter is a different matter, sir.
Okay.
We are not reserving judgment in your matter.
My lord.
Now, next, which one? Similar point, tell us.
When the independent witness can sign in a seizure.
No, that we have seen.
That part is the
Yes, definitely.
object of NDPS Act has to be considered also, Lordship, why it has come into force.
Very good, very good. In your case, that is item number,
30.
the case is similar.
No. There are many aspects which have not been completed by the Islamic Council. I have to.
Is your case also based on absence of signature of independent person? Then we'll take your case up after we decide this. That will help us. That will help us.
But if your lordship decides on the issue of 41B,
Yes.
then I'll be criticized because without being provided.
কিচ্ছু না 30 না 66 না যেটা হলো এক্ষুনি
না না ওটা ওনাকে কেন ওটা ওনাকে দিন ওনাকে দিতে বলুন প্লিজ হ্যান্ড ওভার অ্যানাদার কপি অ্যারেস্ট মেমো ডোন্ট ফরগেট
today please এবার কি 30 action 30
Since council for this meeting, previous matter started with 37 to impress upon your lordship the applicability of the CRPC. As a matter, I start with section 36C. May I take your lordship to section 36C of the applicability? Your lordship, but I am reading the relevant provision. Section 36C, application of court to proceedings before a special court. The same as otherwise provided in this act, the provisions of the Code of Criminal Procedure 1973.
36?
In 36C.
36 AC.
C.
Oh, 36 C.
just a minute sir. Your case is CRM 496
496.
section 36C. Yes.
Provides, same as otherwise provided in this act, the provisions of the Code of Criminal Procedure 1973, including the provisions as to bail and bonds, shall apply to the proceedings before a special court, and for the purpose of the same provisions, the special court shall be deemed to be a court of session and so on. it is not a case, Mala, that the provisions of the Code of Criminal Procedure does not apply to the proceedings under the NDPS, and they do apply. It is right law, Mala, that in case involving commercial quantity, the conditions specified in section 37 of the NDPS Act has to be fulfilled, then only bail can be granted. But my lord, kindly appreciate it is a fact that India was signatory to various conventions against narcotic drugs and psychotropic substances, and in discharge of his commitment, this NDPS Act 1985 was brought into force. But my lord, kindly appreciate NDPS Act 1985 is a draconian, contains draconian penal provision, prescribing stringent punishments, and time and again it has been held by various honorable high courts and as also the honorable apex court, as since the NDPS Act contains stringent punishment and imposes stringent conditions for bail, the provisions contained in the Act must be strictly adhered to. It calls for strict adherence to the statutory requirements. If the statutory requirements provided under the NDPS Act as well as under the code are not properly complied with,
Favorable presumption can be drawn against
Yes,
the in favor of the accused.
first, now may I take in my case, my lord, if the Caesar list and the arrest memo creates a
Just a minute.
Interesting. Balance has to be struck between liberty and the
No, sure.
menace of.
I'll give a reply to the same regarding 36C. It does not say anything.
No
regarding-
peaceful, no peaceful reply.
The judgment of Taylor versus Taylor that has been quoted by the earlier ordinance bench in regard to this particular aspect. I'll take your opinion.
It's good, Lordship, because this thing has to be cleared. That ambiguity is going on.
Yes.
Yes. But in suspicious circumstances, if there is a latent violation of 41B of the CRPC, it destroys the root of this case, as in my case. May I take your lordship to page 21 of my petition?
Just a minute.
He is saying if it goes to the root of the matter, it is a bad arrest in law, therefore it has to go.
So you are page 25 of the well petition.
Yes. This is the Caesar list.
No, page 25 is an order or something. Or is it later? Page 25.
21.
I'm sorry.
Yes.
Is a Caesar list.
Yes. Caesar. The Caesar list is bad on another count. I'll take your lordship to that, but kindly see. Yes, madam, then kindly come to page 24.
You refer 21.
Yes, 21, then 20. This is the allegation.
In 21, what do you want to show us?
Yes, sir. Madam, the allegation is the de facto complainant is the sub-inspector posted at Kumargam police station, and during while he was discharging Naka duty, he apprehended a truck, recovered bought snatch, recovered narcotic substances, then prepared the Caesar list, which is required under section 102 of the CRPC to be prepared by the person seizing, arrested the accused, and prepared the arrest by preparing arresting. Now, Your Honor, the sum and substance is the seizure list as well as the memo of arrest, both are prepared by the same person at the same time in discharge of his duty. Now, kindly compare with apparent eyes the handwriting in the seizure list as well as the arrest. From an apparent view, my lords, it will be amply clear that these two are not prepared by a same person.
Has to be prepared by the same person.
Yes.
Under which provision?
Is there any provision in law?
No lordship, no lordship.
Kindly come to 41, section 41 of the here. B. Every police officer, while making an arrest, shall hear an accurate, visible, and clear identification of his name, which will facilitate easy identification. Prepare a memorandum of arrest, which shall be attested first. Now, this arrest memo has to be prepared by the arresting officer.
Where it is?
In his own handwriting, where that.
Where it is? Under the
You
direction.
can ask his associate.
Yes.
Only net making yes.
But my lord, when he is saying that he is drawing up in discharge of his official duty, he cannot entrust it to anybody else to draw it up. This is my submission.
Again, it will clear our thought. So we are interrupting you. Can't I ask an associate of mine that I am dictating, you write it down? Who will be then preparing? Who you will say is preparing? If I dictate and somebody writes down something, who prepares this document?
Well, then the person who is drawing up is preparing, because I will be left with mere duty of
Putting signature. Putting signature.
Yes.
Is there any bar in 41B?
No.
No, my lord, there is no nothing is said in regard to putting a signature, but it is said that he will prepare the memorandum of arrest.
Very well. We have noted your argument.
Now, my lord, the issue whether compliance of 41B is mandatory or not, may rely on the recent judgment of the Hon'ble Apex Court.
Until.
No, 41 compliance of 41B is absolutely mandatory, there is no doubt of it. But if it be
Yeah, commercial
defined
quantity-
in handwriting, what is the difficulty? If it is been signed by the arresting officer.
No. Lordship, in a case of commercial quantity where punishment is more than 10 years, 20 years, so certain until is below 7. Yeah. And in that case, Lordship, until was observed and bail was granted, which was turned down by the Supreme Court, which I have been.
তোমার ওই পাপ্পু সিংটা একটু দেবে আমি
এখানে নেই আমার কাছে, আমি দুটি ছিল দিয়েছি।
Now, just on a lighter note, is bail a seasonal fruit or you get it round the year?
We get around the year.
Round the year, bail is available.
If they can satisfy the court that it is ripen even enough to get.
The bail shall be deposited. Bail when I mean, for the
Fruit.
in Satyendra Kumar until several judgments were pronounced and several judgments were reported. The judgment which was referred in Union of India versus Pappu was the previous judgment which was passed in Satyendra Kumar until. This is the subsequent judgment. It passed in a miscellaneous application number 1849 of 2021, reported in 2022 10 SCC 51.
But directions were given directly, nothing else.
You cannot put. May I take your lordship to running page 33, internal page 80, paras 25 and 26.
In the judgment?
Yes.
Internal page?
80. Paras 25 and 26.
Para 25 years.
Liberty and reading the relevant portion.
Yes.
The consequence of non-compliance with section 41 shall certainly inure to the benefit of the person suspected of the offence. Resultantly, while considering the application for enlargement of bail, court will have to satisfy themselves on the due compliance of this provision. Any non-compliance will entitle the accused to grant bail. Section 41A deals with the procedure for appearance before the police officer who is required to issue notice to the person against whom reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offence. And arrest is not required under 41(1). Section 41B deals with the procedure of arrest along with mandatory duty on the part of the officer. The duty on the part of the officer as prescribed under 41B is mandatory.
इतना addicted हुए हैं ये अमीर मास्टर
Item 66.
तो हम नट्टा रख दी फिल्म तो ही बोले
May I rely on another coordinate document reported in 2015 Calcutta Law Times 623, although it has been passed in a appeal from conviction, but the ratio laid down in the document. Running pages 12 and 30.
just a minute.
Citation, please.
12 and 13.
Yes.
Well, yes, 41B.
Just few minutes earlier, your lordship were saying in Arijit's case that has been quoted in this judgment and clearly held that if arrest has been not made in accordance with the procedure, the arrest becomes bad. This is an NDPS case.
When it is not an NDPS case, that is also equally bad. So in page number 12, which portion is relevant?
In page 12, the Najib Ahmed's case has been referred to, and in page 13, I am reading the relevant part. We are of the view that the procedure to prepare memorandum of arrest has been provided under the provision of section 41B of CRPC so that the arrest of a person may be proved by the records of it made in manner laid down. Therefore, considering the facts relating to preparation of memorandum of arrest of the accused should not have been accepted by the learned court below as a piece of valid piece of documentary evidence. And the second last para, we have therefore no hesitation to hold that conviction of the appellants cannot be sustained in law, firstly due to reasons that the right available to the appellants under provision of subsection 1 of section 50 of NDPS Act was not communicated to them clearly, individually in unambiguous language, and secondly, the arrest of the appellants on the place of occurrence was not proved due to non-compliance of the provision of clause 1 of subsection B of section 41 of the Act. on two counts, conviction was set aside because they were not communicated.
With regard to the provision of section 50
50
and non-compliance of the provision of
41B mandating that there has to be signature of either a respected person of the locality or his family member.
in your case, the arrest memo, in the arrest memo, respective signatures
No,
are.
no. Completely blank, even no reason has been recorded.
Where is your arrest?
Why is the arrest memo?
24. Page 24.
It is blank.
Yes. No reason has been recorded why it has been, what compelled the arresting officer to keep it blank. Even at least if they have recorded any reason that for so and so reason he has not been able to get the signature of any witness.
Standing order. Standing order.
But in the Caesar list, signature is there.
Yes. In the Caesar list, signature is there. What counsel for the state was submitting is very dangerous. Kindly visualize. Kindly visualize, mother. Caesar starts. And at the juncture when the Caesar starts, they get the signature. Now, arrest has to be effected as per submission of the learned counsel at the end of the Caesar. Now, the law requires, my lord, that after search has to be completed, Caesar list has to be prepared, and then the signature, counter signature of the witnesses has to be taken. Now, what learned counsel of the state submitted that the person who's present at the spot usually go, and that is why member can you visualize how dangerous it will be, my lord? Then
that too in presence of the police person.
Yes. At the time when they start the Caesar, they get
They will be in presence.
yes.
But your submission, when they start with the writing the arrest memo,
Yes.
they will flee.
Now, if that is so, my lord, what learned counsel of the state is submitting, then the police officers are getting the signature of the Caesar witness at the time when they start the search, and not after completion of the search. So they are required to get the signature after completion of the search and then after preparation of the Caesar.
Very good.
Anything more?
Yes, madam. Now, madam.
How much more?
Madam, kindly come to.
কি দিচ্ছে একটু বলো?
There was, kindly come to section 52A, subsection 1 of the MBBS.
What is the page number you just told?
Page 21. Caesar list.
Now, page number, section
52A1.
Is there or is there not a judgment of Justice Chandrachud on 52A1? Are you aware? Please, I may be entirely wrong in thinking what I am thinking, but I want to see that judgment once more.
Not by Justice Chandrachud.
Then,
Mohanlal. Actually, Mohanlal is the mother of.
no, 2020.
be there as it come to the point.
52A, subsection 1 empower the central government to prescribe for procedure for search, seizure and sampling and
52 NDAPS Act or the 52A.
52A.
There's disposal one, disposal.
Yes,
Disposal of seized narcotic drug.
yes. Theta sampling and all. And in exercise of the powers conferred by subsection 1 of section 52A of the NDPS Act, this central government published standing order 1 of 1989. In that, can you come to rule 2.1 and 2.2? It provides all drugs shall be properly classified, carefully weighed, and sampled on the spot of seizure. 2.2. All the packages containers shall be serially numbered and kept in lot for sampling. Yes.
Yes.
This standing order requires that the contraband has to be serially numbered for identification. This is one of the requirements. Now, whether this standing order is mandatory or not, that has been told by the Supreme Court in many cases. I am referring to one.
It says it is mandatory.
Yes, sir. In Rule Iron versus State of Punjab, 2008, 16 SCC 417, internal page 461, para 91. Can you come to para 91?
Just a minute. Para
91. Internal page 460. Your lordship, even I am reading the relevant part. The logical.
just a minute, sir. Just a minute. Let us come to the relevant page. 92.
Para 91.
91. Okay. The logical. Yes, read.
The logical corollary of this discussion is that the guidelines such as those present in the standing order cannot be blatantly flouted, and substantial compliance therewith must be insisted upon. For so that sanctity of the physical evidence in such cases remain intact. Clearly, there has been no substantial compliance with these guidelines by the investigating authority, which is the drawing of an adverse inference against them to the effect that such evidence being produced, the same would have gone against the person.
Now come to the seizure list.
Yes.
So keeping aside the guidelines 2.2 and the reported decision, what is your submission in
My
regard to?
submission is not, there is a requirement. Can you allow me to get into another aspect? Then I'll take to the relevant part.
Don't burden us with unnecessary judgments unless it is relevant.
Yes, I'll take your word.
Unless it is not relevant, don't place.
No.
496.
Internal page 409, para 18 and 19. Kindly see.
Just a minute. Let us note.
Kindly see.
Page number.
Page 409.
Page 409. Page number 409, page 18 and paragraph.
18 and 19.
Yes.
Kindly see rule 2.1 of the standing order.
2.1.
Yes, 2.1.
2.1 is also.
That the drugs shall be classified carefully, weighed, and sampled on the spot of seizure. regarding sampling of on the spot of seizure created a confusion, which was going in contrary to subsection 3 of section 52A, and that part was dealt by the Honorable Apex Court in Mohalla. Now, para 18, my lord, I am reading the relevant part. Be that as it may, a conflict between the statutory provision governing taking of samples and the standing order issued by the central government is evident when the two are placed in juxtaposition. There is no gainsay that such a conflict shall have to be resolved in favor of the
Statute.
statute. There is no gainsay that such conflict shall have to be resolved in the favor of the statute on the first principles of interpretation, but the continuance of the statutory notification in its present form is bound to create confusion in the minds of authorities concerned instead of helping them in discharge of their duty. The central government would therefore do well re-examine the matter and take suitable steps in the above direction. However, only in regard to the drawing of sample, the case of drawing of sample was creating a confusion. Rest apart, my lord, the standing order was in its place.
Sorry, I cannot follow. Will you repeat please your submission?
Only in regard to the place of drawing samples was in conflict. Rest of the standing order, there was no conflict. Now, in regard to this, in para 18, Supreme Court requested the central government to re-examine. Kindly come to page 22 of the standing order compilation, madam. After re-examining this, central government notified the narcotic drugs and psychotropic substance seizure, storage, sampling and disposal rules 2020. I rely on subsection 2 of section sub-rule 2 of rule 3.
Rule 2 of rule 3. Okay.
Provide if the narcotic drugs, psychotropic substance and controlled substance are found in packages or containers, such packages and containers shall be weighed separately and serially numbered for the purpose of identification. Now, what was there in the
Seizure list?
In the standing order, my lord, in 2.2, that all the packages, containers shall be serially numbered and kept in lot for sampling, has been maintained in the rules 2020. Again,
has been maintained in
rules 2020. That is the narcotic drugs and psychotropic storage sampling.
yes. Yeah.
Now, both the standing order as well as the rule has prescribed that whenever there are more than one container or packages, they have to be numbered serially for their identification. This is a mandatory requirement. Now, kindly come to page 16 of my
packages and containers shall be weighed separately and serially numbered for the purpose of identification,
which is akin to the provision of rule 2.2 of the standing order, which was in force at that time.
Yes, but what happened with your seizure list?
It has not been numbered for the identification.
Page 21.
21.
It has not been numbered, mean?
It has not been serially numbered, madam. Can you appreciate?
Serial number is there 1, 2, 3, 4. That number is not sufficient.
So there has to be marked. What the rule says.
Shall be weighed separately and serially numbered for the purpose of identification.
Marking for
on the container.
Yes.
So, sir, label, it is to be labeled.
Yes. And which has to be mentioned in the seizure.
So according to your submissions, these articles were not numbered.
Number for identification. Which was there in the standing order, one of 89, rule 2.2, and maintaining the rules 2022, in sub rule 2 of rule 3. And my lord, most surprising part of this matter is, my lord, I had the opportunity to appear in another matter concerning the same police station. In a FIR which has been lodged by the same person who has lodged this present FIR. I am having the copy of the FIR, madam, of this the other case. Kindly have a cursory look.
Oh, it has been mentioned as exhibit 1, exhibit 2, exhibit
No, no,
3.
my lord. Kindly come to page 11 of my application, which is the FIR in this instant case.
Page 11.
Yes. Written complaint, because treated as FIR in this instant case.
Oh, page 11 of your complaint. Achha.
Copy paste.
Copy pad, please show copy. Even this full stop, commas and all have been copied.
Page 11 and to compare with?
The other case I have submitted before your lordship. There than except changing the name of the accused and the legal number, my lord, even the comma, full stop and all have been copied. And the more manner is.
No, it's exhibit A, exhibit B is not written.
Yes. Yes. That was to be done, but in that case they have done it, but in this matter they have not done. Kindly appreciate, my lord. Each and every single one has been copied. The more manner and everything has.
That is neither here nor there really. Could have been very similar consignment. Who knows?
But my lord, kindly visualize. Is it possible, my lord, that the
There
entire mode and manner is there?
we will be entering into an area of speculation to that extent. We don't need this, in fact. We don't need it.
But what can be done? What can we do that in that case the exhibit marks were there, but here it is not there.
Here it is there, Lordship. I'll show. Each and every packet has a separate exhibit mark after going in. I'll show.
But that has not been brought to the record, my lord, in the FIR or in the.
It will not be. There is no provision to bring. I'll show. No.
How much I will require?
I'll rest my son.
That's all. You have to reply that way.
You want to reply today or some other
If
day?
Lordship permits, I can, or
You don't want to consider all these judgments?
judgments I have given.
No, you don't want to consider his judgment?
Yes.
So then give your reply on Monday
Monday.
or Tuesday. Probably.
Tuesday at 2 p.m. Lordship.
Tuesday, civil matter.
Oh, Tuesday, civil.
Monday to PM.
Lordship, date reference there, then Wednesday.
Huh?
Wednesday. But
Pass the order.
Pass the order.
Difference আমরা এখানে শুনে নেবো কি আমরা চলে যাব।
Then Monday.
Monday,
Monday.
date reference as fee set
3 p.m.
3 PM.
So 2 p.m.
How long will you take? Half an hour?
10 minutes. Because what?
2:45.
Only one more thing, my lord.
One more thing.
Kindly appreciate, my lord, the judgment of the court and the bench relied by the land council for the state
I have not read any judgment. Code of coordinate bench.
The previous
Oh,
matter, procedure on a premise of comparing section 42 of the NDPS Act with 41. But my lord, by the very scheme of section 42 of the NDPS Act, it is completely different from 41.
We have been discussing Caesar all this afternoon. All the Caesars made in July have a touch of Shakespeare because they become Julius Caesar.
wonderful, wonderful.
এই গুলিও না।
And you too, Brutus.
Item number 26, not the item
আবার
number
কি হলো?
26.
Any additional point involved in that or this? That is the only point. Madam, you point that out on Monday when Mr. Ganguly completes. We'll take up your matter. We'll note that this is your point. And additionally, in the Caesar list also, there is no independent witness.
I will argue on that point. I'd like to judgment.
We are fixing it on 2:30, Monday, 2:30.
You appear virtually, no problem.
Grateful, Lordship.
এই আইটেমটা করবে যেটা হচ্ছে 30 heard Mr. Sachin নামটা নিয়ে নাও।
What's your name?
Petitioner Arnab Sengupta for the petitioner. Stop, he concludes his argument. Paragraph lists the matter once again on Monday date now marked 2:30 PM for Mr. Saurabh Ganguly, learned advocate for the state, to make argument in reply. এই আমার এটা নোটটা নিয়েছো?
বুঝতে হবে।
Yes, this also will reserve after we finish. That is enough for Friday afternoon.
Lordship.
Have a nice weekend.